panel. It's before the full judiciary next week. My anticipation is it will move to the House floor. So I hope we're in a foot race here to see who gets to the finish line first. It really doesn't matter just as long as we get there. What I'd like to say to you today is that this is, in my belief, the single most important bill that you will look at this year, or maybe ever. Wow, that's hyperbole, isn't it? The most important bill you'll ever look at. It simply is because our federal government's out of control. You only need to look at the news every day and you know it's out of control, and everybody's rolling their eyeballs. Republicans and Democrats look at it and go, oh my Lord, look at them up there. Totally dysfunctional. Well, we have the power as state legislators to fix that. The founders gave us that power in Article 5. They simply said that amendments to the Constitution can be proposed by either Congress or a convention of states. Not a con-con, as some would like you to believe, and all of that. No one's going to shred the Constitution. All they can do is propose limits on the federal government. It's that simple. But the jump bar for success is very high. First of all, 34 states, as you know, have to pass this resolution and it be aggregated so that Congress is then obliged to call a convention. And then it takes any proposed amendment, and it's only proposed, has to be sent out to the states, just like Congress would. And 3/4 of the states have to pass that. And in any state, if it's done by the legislature, either the Senate or the House could stop it. So the jump bar for this is enormously high. When people talk about a runaway, to me, that's just absolute nonsense. The answer is, I ask people who say, well, I'm runaway. Well, all they can do is wring their hands. And I say, well, what is it you propose? Elect better people. And I always say, how's that working out? So we have a runaway Congress, and we as state legislators have the ability to bring the fix. And the fix is an Article 5 Convention of States. I participated in a simulation in Williamsburg, Virginia, Colonial Williamsburg. It was a magnificent experience with very smart people coming together and working very hard to propose amendments, and they were very sensible amendments. I expect the same out of a real Article 5 Convention of States. We'll get there. We need your help. So pass this bill, please, and know that you are doing the most important work you can ever do in this Senate. Thank you, Mr.
Thank you. Okay, Senator, thank you, Representative Taylor. Senator Rice, would you like to address? Senator Representative Taylor, this is the first time we ever let a member go before a senator. Don't expect that to be happening again. Don't expect that to happen again.
Absolutely not.
Thank you.
Thank you, Mr. Chairman. I will try to be brief, but I'm going to back up in time and kind of tell you how I got to where I am, because I am on all 4 of the bills that we've got listed today as a co-sponsor or a sponsor. Back in 2009, myself, Senator Cash, Senator Massey, Congressman Duncan, and Representative Collins all ran for a seat in Congress. I tell people that Congressman Duncan all talked about what we would do when we ran and got to Congress, and we all believed that literally Washington was broken. We believed in term limits. We believed in regulation controls. We believed that the spending was out of control. At that time, it was about $14 trillion, and that's in 2010. Today, it's at $28 trillion. If you think about that in terms of a household, that's just shy of $90,000 per individual in the nation. Every individual, man, woman, and child, owes almost $90,000 in debt today. My daughter got a check in the mail the other week for $1,400, and she looked at it and I said, well, the good news, it only cost you $6,000 in debt to get that $1,400 check. So, you know, we've got an issue up there, and we need to do something about it. And I think every one of us that ran for Congress, including Congressman Duncan and some of our other colleagues, I think most of us in here served with me in our South Carolina delegation. members, and I think most of them would support this. I think we need a blend of all of these pieces of legislation that we've got. There's some stuff that's missing out of it. If South Carolina becomes the 34th state, I think we need to send a letter to Congress and saying we now have 34 states. We're ready to move forward. I think we need penalties when we do our delegate selection, criminal penalties. If a delegate gets out of track, goes off the ranch and tries to do something that's not in the target specific, however we write this convention of states, or whether it's balanced budget amendment or term limits. But whoever a delegate is needs to stay within the parameters that we set forth here at the state of South Carolina. Like I say, we need 34 states, and South Carolina can be the 34th state. And then once we have a convention of states, it takes 38 states to ratify, and I believe that ought to be done by the vote of the people. And I think those are safeguards that are in place. You know, ideally, if we get to 34 states, what I would like to happen is for Washington to come to us, and I'm talking about Congress, and say, guys, give us a little time. Let us come up with a balanced budget amendment that we can amend the Constitution of the United States, and then you can go back and ratify it. That'd be best case scenario. Do I believe that'll happen? I'm suspect of that. But with that, Mr. Chairman and fellow committee members, I'm going to stop and just say that, I support this. At one time, I was questionable on it. Right now, I believe this is the only way to fix Washington, and I'm asking for your support.
Thank you, Senator. Okay, now I'm going to call on Ms. Benson to give a brief description of the whole Article 5 process and the constitutional provision. Ms. Benson.
Thank you, Mr. Chairman. Mr. Chairman, if I could pass out some documents to the committee members to assist them as they look at this material. And this first one actually is a chart of the process that Representative Taylor put out for you. And it's also a list of the actual provision from Article 5 of the U.S. Constitution. As you can see from the chart, there are two ways of proposing an amendment. Either 2/3 of each House of Congress proposes an amendment, or 2/3 of the states make application to Congress to call a convention of states. And after either of those processes is done, then whatever is proposed must be ratified by either 3/4 of the state legislatures or 3/4 of conventions in each state. And Congress has the determination ability for determining how the ratification is to be made. There's only one time that a ratifying convention has been used, and that was for the 21st Amendment, which was the repeal of the 18th Amendment, which was prohibition. This also gives you a little bit of additional information about the fact that 33 constitutional amendments have been proposed, and only 27 of those have been ratified. It also makes mention that usually whenever an amendment is going through the ratification process, that Congress imposes a time period within which the amendment must be ratified. Mr. Chairman, the next document I'd like to pass out is one that is a comparison of the bills that are currently pending before this subcommittee. And if I could just briefly go over this with you. The first resolution, these are either concurrent resolutions or a joint resolution. The first is a concurrent resolution which would call for a convention of states to limit the power and jurisdiction of the federal government and impose term limits. This is which is known as the COS, the Convention of States model language. It has been passed in 15 states. It has been passed in one chamber of at least 8 states, and is pending in 14 states. Our fiscal impact listed no fiscal impact upon this. S-133 is a joint resolution. It is indeed the same language from S-33. But in addition, it has some provisions about how that a convention of states in South Carolina would be convened and work. It has some provisions in which it tells Congress that it understands Congress authority is to name the place and time for the convention, but Congress does not have the ability to determine the rules for the convention, set the number of delegates, or name the delegates. The convention would be limited to specific listed topics, and South Carolina would recommend that the ratification be by the state legislatures rather than by convention of states. Also, it lists out exactly how delegates would be selected. In essence, there would be 5 delegates selected by the members of the General Assembly, 3 from the House, 2 from the Senate. They could not be members of Congress, but they could be elected officials. Those 5 delegates would then select 5 additional recommended delegates. The President of the Senate would select one of the recommended delegates, the Speaker would select another, and the remaining 3 recommended delegates would become alternates. The delegates would take an oath. If they violated the oath, there would be repercussions and a method of recall. The General Assembly would provide in the joint resolution any kind of rules that the delegates were to follow, and a simple majority vote by the delegates would represent the vote for South Carolina. The delegates and the alternates would be paid the usual mileage, subsistence, and per diem as are paid to members of state boards. S-141 is a concurrent resolution, which is the Balanced Budget Task Force, a model resolution. According to its website, 28 of the required 34 states have passed this. According to Wikipedia, 29 states. Also, you will likely hear testimony today that has been prepared from the work of a professor, and please let me hand out this document that the professor has prepared, and this is Professor Robert Nadelson. His argument is that with the 27 states that have passed a balanced budget amendment, plus the 6 states that have passed multiple application amendments, that makes 33 states have made an application for a convention of states. Therefore, the next state that makes the application would be the 34th or the 2/3 state. And that would, at that point, that Congress would could call the convention of states. Finally, oh, and I'm sorry, one more handout. This is a list from the National Conference of State Legislatures of all of the states that have either constitutionally or by statute balanced budget provisions for their own states' appropriations. Finally, S-363 is a concurrent resolution that would call for a convention of states for the sole purpose of proposing an amendment to set term limits for U.S. representatives and U.S. senators. This is the USTL, the termlimits.com proposed model resolution. 4 states have passed it. 15 states have passed it if you count multiple applications. And in this year, 17 resolutions have been passed in other states. Mr. Chairman, that would be my overview.
Thank you, Ms. Benson. Would any members like to make brief comments before we get to more testimony? Okay. Next up will be Mark Meckler, and on deck means you're second. If you're not a baseball fan, you need to know that. On deck is Chris Neely. I'm saying who's on deck because anybody who is going to speak next, and particularly is in a remote room, needs to come on down to 207 outside the door so you can speak next. Okay, Mr. Meckler, is that correct? Meckler. Okay, thank you.
Mr. Chairman, honorable members of the committee, my name is Mark Meckler. I am the president and founder of the Convention of States Project and Convention of States Action. And we are the organization nationally moving forward this effort on behalf of the Convention of States Project. It is, in this case, we're talking about S-133. The time has come in American history for the states to stand and to uphold their end of the bargain with the federal government. It's extraordinary to note that state legislators were made in the United States Constitution the most powerful people in this country's federal government. I know that when you go through your orientation, when you come here, they show you where the bathrooms are, where your office is, maybe where legislative drafting is, but they don't tell you about your role in the federal government. The Constitution gives you the power, and only you the power, to call a convention, to propose amendments, and to ratify those amendments, being the only people who have the actual power to form and reshape the United States government. That power was not given to the president, was not given to Congress, and though the courts have somewhat usurped it, it was not granted to the courts. I have the privilege and the pleasure of traveling all over this country. I've been in 48 states. Most of them I've been in the state legislatures, working with legislators like you all over the country. And I've often asked myself, why is it that the founders gave you this power? It's become self-evident to me from my travels. The reason is because you actually are them. They served on county councils and county boards. They served in state legislatures and colonial legislatures. And it's not that they believed that you would be better people than those who served in Congress. It's that they believed you would be closer to the people, closer to your constituents, more connected to the people whom you were governing. And they counted on you to be the last line of defense for liberty. They knew that the federal government would spiral out of control, and they gave you the power to rein it back in. Article 5 actually gives you the power to rein in federal tyranny. Now, I often hear the comment that our Constitution is fine just as it is, and mostly people are referring to this Constitution. A lot of you have a pocket Constitution. It's 13 or 14 pages for the full Constitution. But when people tell me that the Constitution is just fine as it is and we don't need to do anything to fix it, what they are not taking note of is this hefty little beast. This says the United States Constitution on the spine. You can order it from the government publishing office. It's about $130. The last edition was printed in 2012, 2,783 pages, roughly over 3,000 pages with supplements. It contains every case ever issued by the United States Supreme Court telling us what this document means. It's expanded dramatically the powers of the federal government into areas we never intended for the federal government to operate: education, energy, environment, commerce, in a broad scale. All of these things never intended by the founders to be touched by the federal government. They were left to your purview. They were left to the people or to the states. And today we operate under this Constitution, and unfortunately the federal government wields enormous power. The debt now at $29 trillion, long-term debt and deficit about $157 trillion, and it's up to you to rein it in. I represent roughly 40,000 people here in your great state, and I ask that you pass S-133 on their behalf. By the way, there are 2 overflow rooms in addition to the crowd here, the vast majority of them in support of S-133 today. Thank you for your time.
Thank you. Any questions for Mr. Meckler? Thank you.
Thank you, sir.
Right, next is Chris Neely, and on deck would be Sam McDonald.
I want to tell you thank you so much for having me here today. I'm here to represent many of these 60-plus people. I lost count because I didn't have time to stay out there long enough in the overflow rooms, but we all are fellow South Indians to support 33 specifically. You know, we got over, Mark said, we've got over 40,000 supporters and petition signers in this state. I will tell you, exponentially growing since the first of the year. We've had over 4,300 people since January. So imagine it. We've been around for 5 years. Imagine if we keep that pace up. People are seeing their freedoms in jeopardy all around this state. I travel all around the state, and you can probably hear this too. I'm sure you've seen it. But I get the good job here. I get to tell you about our great grassroots. We have got the greatest grassroots army that I have ever seen. I say army, political army, a peaceful army, because they want to use the Constitution to save this country peacefully. They love this country. It's a great group of people. Now, right down the road here at Williams-Brice Stadium, I played for a championship high school football team, and I thought that was the greatest team I've ever been involved with. But bar none, this is the greatest group of people I've ever been involved with, because they're doing it out of their hearts. They're doing it because they care about our state. They're doing it because they care about you and me and our future generations. They see our freedoms and liberties slowly going away and they see this country being torn apart because they want to make us all the same. And and I know, Democrats or Republicans, we're not the same here in South Carolina as people in Oregon, California. But when you have a federal government that tells us all what we're going to do, they try to keep us in the same box, and it's really tearing us apart with the fabric. But we have a great team. They're involved at the local grassroots level. Those individuals have decided to get involved in certain groups, such as the GOP, some of them in the Libertarian Party. Some have reached out to all kinds of different groups. They don't care who you are. They just want to know what kind of principles you believe in. You believe this is a great country. You believe we make mistakes, and you believe, though, that you individuals here, that your representatives know us better than those in Washington. We all agree that. We agree in the Constitution is the rule of law, and we want to use the Constitution in Article 5 to help save this country. We've gotten involved in as individuals in certain primaries and general elections to help people that support convention states, these are legislators, and our people as individuals get involved when we see the convention states in an election. That's their choice to do so as individuals, and they're just so involved in their communities. They've reached out back when COVID was hitting, and they got involved in so many different ways. We're here to stay. We care about this country. We care about the people in South Carolina. I want to tell you real quick the difference between, if you want to really boil it down to the difference between all these COS resolutions. All the other ones are a single subject, and in 133, it carries 3 subject matters, and the one we care about the most, a lot of us since the first of the year, is reining in and out of control federal government. The other ones are good too, term limits and fiscal restraints. But a lot of us now care about reining in and out of control.
3 minutes are up. Thank you. And
thank you, sir.
Any questions? All right, thank you, Mr. Neely. Next is Sam McDonald, and on deck is Ken Clark.
So, Mr. Chairman, with your permission, I'd like to yield my time to Ms. Natalie Traver, if that's all right with the committee.
That's acceptable. Ms. Traver?
Traver. Yes, ma'am.
Okay.
It's an honor to have the opportunity.
Sit down if you would, and so you can speak into the microphone.
It is an honor to have the opportunity to speak to you all today. My name is Natalie Traver, and even at 13 years old, I am worried about my country. Thomas Jefferson once said, "How little do my countrymen know what precious blessings they are in possession of which no other people enjoy. Americans do not know how good they have it. And I'm afraid that if we do nothing to fight the growing federal government, we will soon find out how good we had it. We need to put an end to this tyranny before it is too late to save our beautiful country. Convention of States is a shimmer of hope in all this darkness. I believe that there are many good people out there who want to do something to help, but don't know what that something is. Short of running for election, what can we people do to help our country? The answer is COS. By limiting the power of the federal government, establishing term limits, and requiring federal fiscal responsibility, we can finally put up a boundary to this parasite's never-ending power. We can still save America, but we have to act now. I understand that there are risks, but there are risks in everything. Whenever one makes a decision, they must look at the risks and the rewards and decide which one outweighs the other. In my opinion, the rewards of Convention of States far outweigh the risks, but that's just my opinion. All I ask of you is to look at the risks and the rewards and make a logical, educated decision. You may want to consider this. If not Convention of States, what can we do to stop this tyranny? COS may be our last hope at evolution. I will not just sit around as my country is destroyed. I will stand up for all I love and hold dear. I will stand up for America. Thank you.
Thank you. Any questions? All right.
Thank you, Mr. Chairman, member of the committee. My name is Ken Clark. I'm a regional director for U.S. term limits. I stand in support of every Article 5 resolution on the docket today. Our resolution is specifically the term limits one. I wanted to address a couple of things real fast, and I'll keep my comments very brief. You're going to hear a lot of misinformation today about runaway conventions, quote unquote con-cons. You'll hear quotes about Justice Scalia that are taken out of context. And I want you to please understand that facts are facts. You'll hear that the Convention of 1787 ran away. It did not. All you need to do is take a look at the commissions that were given to the delegates that attended that convention, and you will see that they had complete and total authority to do exactly what they did in 1787. You will hear that an Article 5 convention is a quote-unquote con-con. It's not. It's an amendments proposing convention. Period. All it has the power to do is propose amendments. That convention cannot run away either. And the reason it can't is simple. Language matters. The language in these resolutions limits what can and cannot be discussed at a convention. Ours is very specific. Term limits on Congress. The COS resolution has 3 separate, distinct subjects. Nothing outside of those subjects can be discussed at a convention that would be called under the COS resolution. Period. End of story. The language actually matters. So I just want to prepare you for some of the things that you will be hearing, and I'm going to kind of put the cherry on top of that by reading to you exactly what Justice Scalia said about the conventions. And this is a direct quote. The only remedy specifically provided for the Constitution is the amendment process that bypasses the Congress. I would like to see that amendment process used just once. I do not much care what it is used for the first time, but using it once will exert an enormous influence on both the Congress and the Supreme Court. I really want to see the process used responsibly on a serious issue that the alarm about the end of the world can be put to rest. The founders inserted this alternative method of obtaining constitutional amendments because they knew the Congress would be unwilling to give attention to many issues that people are concerned about, particularly those involving restrictions on the federal government's own power. The founders foresaw that and they provided the convention as a remedy. There is no reason not to interpret it to allow a limited call if that is what the states desire. End quote. Thank you. I'll yield my time. I'll be happy to answer any questions.
I have
About right on money for 3 minutes. Okay, Senator Mark.
maybe I'm supposed to know what's a con-con.
They call it a con-con. Basically, Senator, thank you for that question. There's a lot of fear-mongering that goes on around Article 5. And so what they will want you to believe is that it is a constitutional convention. Con-con is short for constitutional convention.
Isn't that what we asked for?
No, we're asking for an amendment and a convention for the purpose of proposing amendments. That's what we're asking for.
All right, so 5 states asked for it on term limits and 29 states asked for it on balanced budget, and that's 34. And they get up there, the 5 that asked on term limits, they can't speak on the other issues, and the others can't speak on this issue.
Senator, there have been to date more than 400 different Article 5 resolutions passed by the states. Virtually every state in the union, not all of them, but virtually every state in the union has passed an Article 5 resolution. So the question becomes
33 states.
Not so far to date, not 34 states have passed.
That's at 33.
Well, according to the balanced budget people, 33. But so far, 34 states have not passed a resolution with the same language. That's why we haven't had an Article 5 convention yet. they have to have the same language. Because otherwise, of the 400 resolutions, we would have already had one. But that's why I referred to earlier, language matters. We have to have 34 identical resolutions pass in order to call that convention.
I just want to make sure I heard you say they got to be identical.
Yes.
Okay, thank you.
How identical?
They have to aggregate, and the language, the operative language, like for instance, Convention of States has 3 subjects. The operative language has to match. It doesn't have to be word for word, comma, T for T, I for I, but they have to have the same subject matter. Term limits on Congress is pretty self-explanatory. Limiting the size, scope, and jurisdiction of the federal government is pretty self-explanatory. Fiscal restraint on the federal government is pretty self-explanatory. Balanced budget amendment, pretty self-explanatory.
So your opinion is you cannot aggregate a Article 5 resolution that is the Convention of States resolution, which includes term limits, fiscal restraint, not balanced budget, but fiscal restraint, and reining in federal power. You can't aggregate that with a resolution from another state that just deals with term limits or with a balanced budget. You can't aggregate those two together? In your view, is that correct?
No, that's not what I'm saying. The Convention of States has term limits included in their resolution.
Right.
Our resolution has term limits, so those would aggregate.
So you are saying then that if we passed a Convention of States resolution, would we be the 34th state to pass a balanced budget resolution, and then an article would be in order? An Article 5 convention would be in order?
You know, I hesitate to answer that question. I'm not an attorney, and I don't know the answer to that question as to whether or not that would aggregate. You would have to ask. I think Mr. Meckler could answer that question better than I could.
Okay, all right.
But I'm not an attorney, so I hesitate to answer that question. I don't want to give you misinformation.
All right, thank you. Any other questions? Thank you, sir. Okay, next is Lillian Johnson, and Jane Thompson is on deck. Is Lillian Thompson here? Lillian Johnson, I'm sorry. Lillian Johnson. Okay.
Skip over to.
All right, I'll skip to Jane Thompson.
Chairman,
Senator.
she was here earlier. I saw her. I think she's in one of these other rooms.
Okay, for those who are in another room, when I call one speaker, I'm calling the next speaker in line. That's the person on deck. Y'all move on down to this room. Stand outside the door so we can get to you. But I'm going to go ahead and move on to, if they show up, we'll hear from them later. But John Perna, is he here in the room? Evan Mulch, is he here? Okay. Okay, we'll go online now at the moment, and so we had Judy Kaler. Is Judy Kaler online?
Yes.
Okay. You're recognized for 3 minutes.
Thank you. If you think you're voting for an application asking Congress to call a limited convention, you're mistaken. Today, it's obvious that the pro-convention strategists don't believe that their lobbyists, that in their lobbyist talking points, that 34 states must pass applications with the same or similar language to trigger a convention, and that the convention can't veer from the subject of the applications. Their strategists are well aware that there's no such thing as a limited convention. They've written about it, and they're expecting Congress to mix and match applications in order to come up with the 34 states needed to call a convention. Lobbyists are telling you that the convention will be limited to the single subject or subjects of the application that you're voting on, thereby assuring you that the convention won't run away. But these are false assurances to get your vote. U.S. term limits passed its single subject application in only 4 states. Yet their website shows they've inflated that number by 700% to 28 states by counting every COS application that contains term limits, along with the applications of 13 more states whose applications have nothing to do with term limits. Those states passed irrelevant applications up to 232 years ago to get a Bill of Rights, to avert the Civil War, to directly elect senators, and plenary or unlimited applications which just ask for a convention. The balanced budget groups are doing the same thing. There are 27 active applications they have over the past 45 years. Yet they were testing the waters in February to claim Georgia as their 34th state, aggregating 6 of those obsolete applications with 27 BBA applications. The sponsor in Georgia had assured the other senators publicly that all 33 states passed the single subject BBA application, so the convention couldn't run away. As Georgia's application languished in the House, Mississippi stepped up to the plate with a new application in March. Mississippi's aggregation clause named the 33 states to aggregate as Georgia's, same as Georgia's, and brazenly stated in the application that it was to be aggregated with both, quote, presently outstanding balanced budget and unlimited subject applications, unquote. And now South Carolina is talking about being the 34th state. Any application you pass can be aggregated with obsolete, irrelevant, and unlimited applications dated centuries ago to reach the 34 states required for Congress to call a convention. Why would you think the convention would be limited? And Rob Nadelson's aggregation does that with those 6 states. This isn't a race to get to 34 that we're watching. They're already there, right and left, to trade away your liberties. This is a public relations campaign to convince Congress and state legislatures that the American people are demanding.
You could wind it up.
I'm almost
3
done.
minutes.
That the American people are demanding an Article 5 convention. They're trying to convince us when most people have no clue what a convention is or what's at stake. It's all smoke and mirrors. It should make you wonder why there's so much money behind this. Thank you.
All right, thank you. Any questions?
Mr. Chairman,
Senator,
what, I didn't get her name. What's her name?
Judy Taylor, C-A-L-E-R.
Where is she from?
California.
Ms. Taylor, where are you from?
I'm from California, Nevada County, California, same as Mark Meckler was from till he moved to Texas.
Okay. Mr. Chairman. Senator. Thank you. Could we ask if they are attorneys, just let us know? Yes. If anyone is an attorney who's a speaker, would you please indicate that? All right. Thank you. Mr. Perner, John Perner. And Lillian Johnson or Jane Thompson or Evan Mulch, who are actually here in Columbia but have not shown up next. But if y'all could come to the door. Mr. Perner.
Yes, sir. Senators, we all agree we live in a time where about anybody with an IQ above room temperature understands that there's terrible corruption at the federal level. We don't dispute that. It seems that there's a high level of desperation about how to fix that. That turns out to be the disagreement. It seems that everybody agrees that there's foreign interference in our political processes. The only disagreement seems to be as to which powers it is that is interfering and which political processes they are interfering with. It should be obvious to everyone in the political spectrum, in any part of the political spectrum, that it would be much easier to rig a constitutional convention than to rig an election. The fact is, every single bill must be passed by the House of Representatives. Every single congressman must be elected every 2 years. If we had honest elections, it would only take 51% of the voters to demand that the elected representatives balance the budget. This only needs to be done in 235 districts. Of course, 51% of the voters can also limit terms on any election day. It's called an election.
Congress could balance the budget in one day if they wanted to do it. 51% of the voters could balance the budget if they wanted to do it. If you do not have 51% of the voters, how do you think you can get 3/4 of the states? It's a different process for a different reason, because the objective is not what you're being told. All Congress would have to do is stop voting to spend all that money. Yet today, there exists a movement that goes beyond this naivete. The assertion is that while we do not have enough public awareness to use a process that requires only 51% of the voters in only half of the congressional districts, we will be able to prevail in another process that requires 3/4 of the state legislators. There seems to be no notice taken of the fact that these state legislators are also elected by the same voters who have failed to change the congressman at any given election. We are to have some assortment of delegates who will not be elected directly by the people. The illusion is that this group of delegates who will not be elected directly by the people will save the people from the elected congressmen who continuously vote for an unbalanced budget. Of course, the budget can be balanced on the back of the taxpayers. They don't specify that the balancing of the budget will be done by the reduction in spending. It can be done by the increase in taxation. The illusion is that this group of delegates are going to be like the people at the Constitutional Convention of 1789. These were the leaders of a freedom movement who just defeated tyranny. Who will be the delegates this time? George Washington, Thomas Jefferson, and James Madison are not going to be there. Do state legislators consistently pass legislation that protects us from unconstitutional usurpation right now? We are being told that because of the unconstitutional usurpation, we need to amend the Constitution.
Mr. Byrne, if you could wind it up to 3 minutes, Rob.
Oh, my goodness. That's not very much. We're being told that what the Constitution already says should not be done is being done, and therefore what we should do is write a new Constitution. And so we're going to tell them again what they shouldn't do. This is like you put some money on the sidewalk and say nobody's allowed to steal this money. You come back the next day and it's gone. So what are you going to do? You're going to put some more money on the sidewalk. This time you're going to put 2 signs out there that says nobody's allowed to steal the money. Boy, that'll fix them. Okay. All right. My time.
Any questions for Mr. Burnham? Thank you. Okay, next, Evan Mulch, and then Jane Page Thompson.
Hi, everybody.
Okay, and anyone who's an attorney is supposed to fess up. So,
law school did not let me in.
Okay.
Okay. The American Legislative Exchange Council is behind the call for an Article 5 convention. This is the same group that wanted the Trans-Pacific Partnership. Democrats and Republicans both should be on the side against the Trans-Pacific Partnership. So my question is, why would any group advocate for the Trans-Pacific Partnership? We know President Trump stopped it. Thank God he did. I'm sure everybody here was against the Trans-Pacific Partnership when President Trump went against it. But why is the same group, the American Legislative Exchange Council, wanting to call this Article 5 convention? They've actually wrote the handbook for it, and they're the ones that are using Rob Natelson as an expert for them, just as the Convention of States uses him as well. So those of us who are Americans, especially those of us who are South Carolinians, need to recognize when there is a deep state, when there are people who want to destroy the sovereignty of our state. We care about having a governor. We care about having state representation. We care about having counties, local police forces, sheriffs that represent the local communities. Why is it that the American Legislative Exchange Council, a group that supported the Trans-Pacific Partnership, a sovereignty-ending union that would have destroyed the sovereignty of America piece by piece, why do they also want to call an Article 5 convention? And that's something that all state legislators and state senators should be aware of. Convention of States Project once had it as Justice Scalia was their endorser. Justice Scalia passed away before the Convention of States Project was created. He never endorsed the Convention of States Project. Fortunately for the family of Justice Scalia, a lot of us exposed that, but it wasn't until years after Justice Scalia's endorsement was taken off the Convention of States website. I sure hope when I pass away that I'm not added as an endorser to the Convention of States Project, especially if I did. Convention of States Project leader here, Mark Meckler, once offered to give Rush Limbaugh's company over $2 million to pop up the Convention of States Project. Rush Limbaugh, rightfully, bless his heart, I know he's passed away, but bless his heart for not taking the money and not puffing up the Convention of States Project. We South Carolinians are smart. We desire state sovereignty. We do not desire to have it taken away by groups that want to destroy national sovereignty and state sovereignty. We do not want a one world government. We do not want to give in to globalists. Just look at the sponsors of the American Legislative Exchange Council, AT&T, Koch Industries, these major companies that played a role in us having a U.S. election for president that did not go our way. Everybody just imagine how great a convention is going to go, an Article 5 convention is going to go, if we can't even have U.S. elections go with the integrity that U.S. elections should have. Greenville County, the county where Jim DeMint is, just had a convention last night, a Republican convention. It looked like a runaway to me. There's still a lot that's coming in, but we can't even run our county GOP conventions correctly.
Mr. Mulch, your 3 minutes are up. You can wind it up, please.
Jim DeMint is also a top endorser of the Convention of States Project. I would question whether or not Jim DeMint may have been involved with what happened in Greenville County last night. We know, those of us who are aware of the Republican Party in South Carolina, the Republican Party does not play fairly to those of us who are the average citizen. We've gone to state conventions where there's runaway conventions. And to tell us that this Article 5 convention is absolutely safe is a lie. We don't know what will happen in Article 5 convention.
Go ahead and wind it up.
Well, God bless everybody for being here. I know a lot of people are here for the first time. They're Convention of State supporters. There's a better way to do this if you just listen to what I've said and you've taken notes. We as Americans need to study our U.S. Constitution, and we do not need to give in to this belief that we have an annotated Constitution. We need to hold our congressmen accountable, our state legislators accountable, and to all of you here that are here for the vote, I just hope that you vote against these bills. This is not a good time to call an Article 5 convention, and that's what Justice Scalia said years before he passed away.
Any questions for Mr. Mulch?
What's his name?
This is Devin.
Devin Mulch.
Just like the stuff you put in your flower bed. You'll never forget that, will you?
Okay, thank you.
Mulch in your flower bed? Somebody had a question about that?
308.
Okay.
I like you. You're a good lady.
Okay, next up is Jane Page Thompson, and then on deck is Patience Boyce.
Thank you, Mr. Chairman. I'm Jane Page Thompson. I'm from Aiken, South Carolina now, but I hail from the state of Virginia. And a lot of people keep talking about the founding fathers. Well, I am proud to be a descendant of 5 of the people that signed the Constitution and 4 that signed the Declaration of Independence. So as a person who realizes my DNA loves politics, you all have seen me here before because I've been engaged in our political process since I moved to South Carolina 20 years ago. And I'm very concerned, not for our federal delegation, because I think they are doing a great job, but I'm really concerned about other states that aren't as small and connected to the citizens as we are here in South Carolina. Now, there seems to be a lot of testimony that you're hearing today, Mr. Chairman, about the fact that your Bill of Rights is going to be tampered with, that there's going to be a runaway convention, that somehow the rights we have now are going to be tampered with. In fact, I think what's going to happen at this convention is going to be a reiteration of what was supposed to have happened in the Constitution in the first place, and that other than protecting our government from military invasion, everything else is up to you all in the state legislature. And frankly, I want it to stay that way, because whether you're a Republican, a Democrat, independent, or libertarian, in this state house, I know you will listen to me when I come to you, and I thank you for that. So there is no jeopardy for my right as a woman to vote. There is no fear that any kind of discrimination could occur in the outcome of a convention of states. But what can happen is we can have term limits, we can have fiscal restraint and balanced budget, and we can limit the federal overreach that is happening at an expedited pace since November. And I encourage you to protect the rights of the citizens of South Carolina and in your home districts, because we are at a point where if you don't do it, I don't know who will. So I encourage you to vote yes for this, for our future and for our own freedom. God bless you all, and thank you.
Thank you, Mr. Chairman. Senator from Aiken.
Questions? I'm so sorry, Mr. Young.
Mr. Chairman, I want to thank Ms. Thompson for coming to Columbia to testify. She's my constituent. I want to thank her for her advocacy, and it's my understanding that you are here speaking on behalf of the Convention of States bill, Senate Bill 133.
133, yes, sir.
Yeah, okay.
That's what I signed up under. I'm so sorry.
Thank you very much.
Thank you all very much for your time.
Thank
Any
you.
other questions?
Patience Boyce, and on deck would be Patricia Souls Rosenthal. Is Patience Boyce here? Okay. Well, I heard Patience voice. I heard Patience voice in the hallway is what I heard.
Okay. Anyway.
Okay. And next will be, after Patience voice, will be Patricia Souls Rosenthal and then Paul Armour. So come on down if you're upstairs.
Okay. Now,
Miss.
I think the federal government should all be fired. I mean, seriously, why do we need them? What are they doing for us?
We don't answer questions. We ask questions.
Okay.
I'm apologize.
Okay, well, I started going for the conventions of states because I seen it as the only peaceful resolution without having riots, and which are the Democratic Party likes. Anyway, I think the conventions of states is our last resort to get people to come together and try to save this country. I have grandchildren and children that are coming up in a world that is chaotic and ran by a bunch of people that are more interested in themselves, more interested in making money, more interested in making a name, more interested in making a business. This is not what the government was supposed to be. This is not what our federal government was meant for. It was meant to protect the people. It was meant to protect our rights. It was meant to protect the God-given rights that we are given, that Jesus died for us to have, that nobody, just gave us. I mean, we were born with these rights, but yet they're being taken every day by our federal government. And for money, for somebody to make a better name for themselves, or for somebody to, just to be pure out evil. And I think that there is a good bit of Americans that are pretty sick of it. And I believe that the conventions of states is the last resolution before something really terrible will end up happening.
Thank you. Any questions? Do you have a particular bill that of these conventions, of these Article 5 bills that you're supportive of?
I'm supportive of term limits. Definitely, they shouldn't be living their life in there. I'm supportive of that completely.
All right, thank you. Any questions?
But to fire them all outright, I think would be the best resolution to do that and then start over.
Thank you.
But thank you for your time.
All right, thank you. Okay, Patricia Souls Rosenthal and then Paul Armour is on deck, and Sharon Clark is in the hole. That means you're third. No one's there? James Hepburn, not James Hepburn. Okay, if you are here, y'all come on down and we'll move to folks online. We have Vicki Simmons. Is she online? Vicki Simmons?
Yes, I am.
Okay. You have 3 minutes.
Thank you. Good afternoon. My name is Vicki Simons, and I live in Aiken County. I oppose a proposed convention of states, aka Article 5 or Constitutional Convention, for the following reasons. First, all people are created equal and have been endowed by their Creator with unalienable rights that cannot be taken from us or given away. And governments are instituted among men to secure these rights. During the Constitutional Convention of 1787, the delegates engaged in a runaway convention, replacing the Articles of Confederation with the Constitution of the United States. It will be impossible for delegates to a convention of states to control the event, as proven by events in 2020, the violent riots that took place in many U.S. cities, and vote fraud in the general election. Many people who hate our country want to replace our Constitution with socialism, and a convention of states will help them do that. Second, our founding fathers instituted a system of elections instead of limiting terms of office. The Constitution was set up to let the people elect a U.S. representative every 2 years and the state legislatures to elect 2 U.S. senators every 6 years. In 1913, the states' voices in Washington, D.C. were eliminated through the 17th Amendment, helped to restore South Carolina's voice in D.C. by passing a resolution to repeal the 17th Amendment. Third, federal spending is out of control because the limits of the U.S. Constitution have been ignored. Back in March, South Carolina's proposed budget of about $30 billion included about $9 billion in federal money. You cannot rein in federal spending while simultaneously voting in favor of state budgets relying on federal money. Even so, a balanced federal budget does not mean that the money is spent only on constitutional provisions. To help federal lawmakers spend money only on constitutional things and thus reduce their budget by about 80%, I urge you to vote against state budgets that include federal money. Fourth, every state in the USA is guaranteed a Republican form of government, meaning we are ruled by law. In your oath of office, you swore or affirmed not to be subservient to the federal government, but to preserve, protect, and defend the Constitution of this state and of the United States. Only federal laws made in pursuance of the Constitution are the supreme law of the land. When federal laws violate the Constitution, state officials must oppose them. The solution, which is already in your hands, is in Article 6 of the Constitution, nullification of that which is not constitutional. The problems on the federal level are not due to problems in the Constitution, but rather misinterpretation, wrongful application, or lack of enforcement altogether. Many Americanists and I very strongly urge you to oppose any and all calls for a convention of states. Do you have any questions?
Thank you. Are there any questions from members? Okay, thank you. Thank you, Ms. Rosenthal.
I think that's Ms. Simmons.
Simmons, I'm sorry. Apologize.
No, I apologize.
Simons, thank you.
Senator from Aiken.
Yeah, Ms. Simons, we want to thank you for your interest in this legislation. I noticed you're from Aiken County, and I wanted to thank you publicly. Thank you.
Thank you.
Patricia Rosenthal. Sharon Clark. Okay, Ms. Clark, you have 3 minutes or less.
Sounds good. Oh, sure. Thank you. Bye-bye. Bye, Kathy.
Okay, bye-bye.
Bye.
Yep. Thank you. Good afternoon, Senators. I want to echo a statement that was made here earlier. Congress is broken, but I would add that the Constitution is not broken. Now, quite a few folks here have tried to assure you that a convention of states can be limited and that all that's necessary is the limiting language. But South Carolina is just one state. Once called, such a convention would be more powerful than Congress, the White House, the Supreme Court, or even state legislatures. Nothing has power over it. Such a convention would have the power to rewrite portions of the Constitution or even scrap the whole Constitution and give us a new government. South Carolina is a large state, but I think probably that population-wise, we're very tiny when compared with the heavily populated states. And I think that you will agree that the people in New York, New Jersey, Illinois, Michigan, and California are not on the same page as South Carolina with regard to expectations from such a convention. The entity that we are trying to rein in is Congress. But Congress would have the power to decide when and where a convention would be called and how delegates would be selected and the apportionment of delegates per state. Will tiny South Carolina be outnumbered by the more heavily populated states? But there is a better way. There is hope. Article 5 also provides for an amendment process not requiring a dangerous convention. So why open a Pandora's box? If we are serious, and I mean South Carolinians, if we are serious about Congress that adheres to the Constitution, then we will vote for constitutionalist candidates and not what the parties offer. And because, frankly, I can't see much difference. Now, if you are serious about reigning in Congress, you can stop accepting federal money.
Ms. Clark, if you could wind it up, you're at 3 minutes.
Federal money with strings attached. For very soon, I believe, the money trees in Washington will stop producing, and we will be left holding the bag on some of these programs. I again urge you to oppose a dangerous call for a constitutional convention or convention of states or Article 5 convention. They're all the same. Thank you very much.
Thank you. Any questions? Okay, thank you. Next. Okay, we've already had that. Okay, next is Paul Armour and James Hepburn, Jimmy Hepburn. Okay, Mr. Hepburn.
Thank you, members of the Senate Judiciary Subcommittee, for letting me speak. I'm speaking on 174. Should I speak later, or is this the appropriate time?
No, later.
174 is the other bill. It's the
We should speak, like we're trying to get the Convention of States speakers through. Well, you're here, you go ahead and just go ahead and speak to it since you're here.
I'd like my words to have as much effect as they possibly can, so if I can speak at the appropriate time when it's fresh in your mind, would it be possible?
That'd be good, yes. Okay. If you can wait, that'd be better. Thank you. Do we have a Paul Armour? A William Olson? I'm going to read the people I have left. William Olson is here. Okay, he's virtual. Okay, Mr. Olson.
Thank you, Mr. Chairman. I appreciate the opportunity to give a few remarks. My name is Bill Olson. I'm a lawyer. I confess to it. In Virginia, I've been practicing constitutional law for about 45 years. And together with Herb Titus, a former founding dean of Regent Law School, we prepared a paper exposing some of the false assurances and false promises of the Convention of States, which we submitted, I hope has been distributed to the members. I'd just like to summarize some of that today. I filed over 250 amicus briefs in state court over the years, and mostly on constitutional issues, and want to bring that to bear in this case. The paper we wrote exposes the false premises for the convention, and then explains why the assurances that there will be no mischief from such a convention are untrustworthy. First, there is no problem with the text of the US Constitution, and it's folly to assume that if the text were only made more clear, that the forces supporting big government would concede the ground. And it's certainly not clear that the constitutional text could be improved at a convention. In a sentence, the problem we face is that by all branches of the federal government having rejected the Blacksonian Christian jurisprudence approach, whereby judges declare the law, rather they've adopted the Darwinian evolutionary worldview, which believes that every generation knows better than the framers did on how we should best be governed. So the problem is not in the text, it's in the hearts of these leaders. Secondly, there's a way to victory without changing the text. I mean, only a few years ago, the Supreme Court and all the lower courts viewed the Second Amendment as a meaningless relic. And along came Dick Heller, and Justice Scalia defied all the legal scholars, and he said the Second Amendment supported an individual right. That was a major victory. And that's why most of the stalwart gun groups like Gun Owners of America, National Association for Gun Rights, strongly oppose the Constitutional Convention, whereby we could lose the Second Amendment. Also, until 2012, the Fourth Amendment was largely read out of the Constitution. It was, rather than looking at the property basis of the amendment, which addresses persons, houses, papers, and effects, the court said, we'll just protect a reasonable expectation of privacy, whatever that meant. But then again, Justice Scalia came along and gave us the Antoine Jones case in Florida v. Jardines, and he restored order. And he said, the key is the text, history, and tradition of the document. And we've even had Justice Kagan say we're all textualists now. Let's hope that's true. But the Supreme Court is far from perfect, but if it cannot be trusted to interpret the language that is already clear and protects our God-given rights, how can it be trusted to review, modify language, or even review and resolve the disputes that will come from a constitutional convention? It is true that
Your 3 minutes. Your 3 minutes are up. If you could wind up your comments, please. Then take questions.
Just two quick things. I would say that just based on the 2020 election, we aren't even sure we could count on the accuracy of a ratification vote. And I would urge all of you not to put into jeopardy the magnificent constitutional covenant that we have and open it up to radical revisions and potentially devastating changes. Thank you.
Thank you. Any questions? Senator from Greenwood.
Thank you for appearing today, and thank you for all the work you've done on the Constitution. Let me ask you a quick question about, is there any way in your mind that you could actually have a convention of states, which is constitutional? You do agree with that?
Of course.
Okay. Is there any way that you could actually do it? For instance, if you decided to make sure the rules were all the same and that each state had exactly the same rules and each state had exactly the same language on what they could do or not do, and each state had the same rules as to what their delegates could and could not do, and in the event any one of them moved away from that, then the entire process would be void ab initio?
I really don't see how. The Constitution vests in Congress the power to make the call, and the call could include the rules. There's nothing that prohibits that, and we don't know what Nancy Pelosi and Chuck Schumer are going to do when they issue that call. And I don't think the state legislatures can control this process at all. Once enough states come in, ask for the Congress to make the call, the Congress issues the call, then it can be totally outside the parameters of the state legislatures because it can go to ratifying conventions. And I don't see how it can be kept under control.
I understand what it says about the Congress does the ratifying conventions and sets forth that, but I'm talking about before that. I'm talking about at the time when they get together. It seems to me that the convention themselves can make their own rules, and at that point, they're above Congress and everybody else at that point while they're in that convention for that limited, very limited, specific purpose.
And that's an excellent point. I think they can make their own rules, and even if there were some standard by which to judge them, who's going to judge them? The Supreme Court didn't even want to get involved in the legitimacy of the last election. It's a very difficult issue. It's a thorny matter. I quite agree.
All 34 could, though. All 34 could agree on the same absolute same rules and agree that those rules would be the rules that are adopted. And if any second, any one of those states withdrew from that moment, the entire process is ended. The very second that anybody removes themselves from the rules or tries to change the rules. I'm agreeing with you that we have to be very cautious about runaway conventions. But our Constitution lays out an opportunity for us, if we've got a runaway government, to try to take steps to help us with it. I agree. I think our Constitution's wonderful. It's fine. It's the best document that God and man has ever created together. But it seems to me at the same time that we're in a situation where we've got a government that has lost its mind. And if we don't, I heard today it was $90,000 per human being in this great country, and they'll never pay back that debt. So how we approach it, it needs to be a unified movement by the states, exactly the same language, exactly the same rules. And if any one of them withdraws or changes, then the entire process, we go home. The whole process is vote ab initio, and we all agree to that up front. Is that possible?
Actually, I don't think so, because the way the clause is written, once the states trigger the call to the convention by Congress, the state legislators lose control. And at that point, anything can happen. There are other constitutional methods, and I would very much urge, it's not this or nothing. Article 1, Section 10 has provisions on interstate compacts, which have never been used sufficiently between states to assert state liberties. And it's something we've worked on for years, trying to have an interstate border compact. There are ways to do this, but this is not the way, I would submit.
Well, again, it would always be better if Congress would limit its own terms or Congress would reel in its own budget, and they're not going to. It's pretty clear to us now that that's not the case. So it leaves us with our other constitutional method, i.e. the Convention of States. And again, I would hope, and this has been suggested by some, if we do come in at them unified completely with exactly the same language, the same rules, everything, then Congress will get off its duff and do what it's supposed to do, with the simple threat of that. Thank you, Mr. Chairman.
Thank you. Mr. Olson, how much comfort do you assign to the 3/4 ratification requirement? Is that not a measure that would keep a runaway convention from actually being ratified, or amendments actually being ratified? I'd like to understand your thinking on that issue, because to get 2/3 together to agree to actually have a Article 5 convention, I think is much easier than getting 3/4 agreeing to a product of that convention that was a runaway convention. And because everyone's optimistic about we're making some changes, well, the changes are unreasonable, not what we anticipated, and then you've got to have even a greater majority of the states to ratify. So I just want to know, in your view, how much comfort does that provide to, or should provide, in diminishing the chances of a runaway convention?
Well, the framers put it there in that hope. The problem that we have, I think, is that we now live in a country where we have lost control over many of the means by which we would stop the ratification in those states. We've lost control over the mainstream media, over academia, public schools, law schools. The law schools are unbelievably bad on these issues. They would prefer to have no state power. Big law, big labor. We just see what big business is doing in Georgia and trying to control what the legislature does there. The FBI and the Justice Department are out of control. Foundations. I just see so many forces arrayed against liberty that I would not want to put this constitutional covenant at risk at this time. I think that is the problem. I would have felt better about it 20 years ago than I do now.
You think the long march through the institutions is almost complete? The Gramsci long march through the institutions.
We are well along the road, and the one thing that protects us is the divinely inspired text of this Constitution, which we rely on over and over and over again to protect our liberties. And if we lose anything, you know, take a look at the polling on the First Amendment. Young people don't believe that you should have the right to speak your own mind if it hurts someone else's feelings. Other polling shows that there are many people who think we should just only have the government have guns. Well, the purpose of the people having guns was to make sure the government didn't ignore all the rest of the amendments. So it's a dangerous time, and I would suggest that this is the wrong solution. And I would suggest that taking another fresh look at Article 1, Section 10 interstate compacts is a very good substitute.
Okay, thank you. Any other questions?
I have one.
Senator from Orangeburg.
So the Senator from McCormick was asking you about if anybody violated the terms that it'd be void ab initio, but there's 16 states that are going to be at the convention that didn't vote for it, right? And those 16 states may be some of the biggest states with the most votes. I mean, the only way the rules can be established is by Congress, not just by 34 states deciding rules for the other 16. Is that right?
That's my view. Yes, sir.
Okay, thank you.
Mr. Chairman, the documents that Mr. Olson and that everyone else has submitted to the staff have been put together by Ms. Patterson and Ms. McGee for the subcommittee members. So there are packets available.
Okay, thank you. Okay, thank you. Next is Sherry Irwin, and then Holly Albrecht, and then David Biddulph.
I'm here.
You may be online. Sherry, you're online?
I'm on the phone, yes. Okay, I am opposed to calling for any type of convention. First, you need to understand who funds Convention of States. It's an open borders group called Koch Enterprises. They want to get rid of our Constitution because they are globalists. And so you have to ask yourself, why would we support this at all? In the congressional research in April 2014, Congress determined that Congress will have sole authority on the convention. It says so in Article 5. They will have the power to pick the delegates. Did you know they can pick themselves as a delegate? Now, that's a way to rein in the federal government, right? Let them be delegates. They can decide how many delegates. People are saying it's only one per state. Now there's talk about making it like the Electoral College, where South Carolina would have basically no vote. The big question is, why did our founding fathers put the convention method in there? The reason our founding fathers allowed the anti-federalists to put it in there, the anti-federalists wanted it in there because they wanted to call another convention to quickly throw out our current Constitution, because we have a right in convention to throw off our government and start over. It says so in the Declaration of Independence. Our founding fathers threw off the articles. They were told by the state, you can only do this, and it took 100% of the states, and instead they shut the doors, they threw out the articles, they started over, and they came out the lower threshold. There's actually a constitution ready to go where the states would be eliminated. They would come out, the country would be in 5 sections, and the threshold for ratification would be a piece of cake, and you would be gone. And the reason our founding fathers allowed the anti-federalists to put it in there, Madison and all the rest that were instrumental in throwing out the articles, was because they knew that we had a right, whether it was in the Constitution or not, to call for a convention and throw off our government. But guess what? within a year of our Constitution passing, the Anti-Federalists started a campaign for a new convention to throw out our Constitution in Madison. And Alexander and John Jay, who were instrumental in throwing out the Articles, campaigned against having an Article 5 convention because they knew darn well that that was put in there to throw out our Constitution. There's nothing wrong with it. We have our Constitution now. You guys have the power. I am telling you, you have the power now. It's called the 10th Amendment. All you have to do is say no to taking federal dollars, or, they're doing unconstitutional things. You simply say, we're not going to enforce it in the state of South Carolina. That's all you have to do. I am telling you, there is dark money. George Soros is funding hundreds of other groups, and they're sitting back and letting conventions of states do all the legwork for them. I beg of you guys, do not pass this. If you care about the future of your children, for the love of God, stop this. Thank you.
Thank you. Any questions? Sherry Irwin. Okay, next is Holly Albrecht with League of Women Voters, and after Holly, David Bidoff.
Okay.
Holly?
Yes. I'm Holly Albrecht. I'm co-president of the League of Women Voters of South Carolina and a retired economics professor at Clemson University. And my primary concern is the economic implications. I found lots of really useful information from my predecessors. I'm not going to repeat any of that. The central goal of the Convention of State Supporters is to greatly, quote, limit the power and jurisdiction of the federal government, unquote, and to send most governing authority to the states. And as an economist, I see some difficulties for that in a global economy. In 1787, the delegates to the Constitutional Convention were facing hostile forces at home and abroad. Abroad it was Britain, at home it was Native Americans, and they recognized the need to speak with a single voice in the world. Large nations such as Russia, China, and India all have strong central governments that can speak with single voice on issues like trade, war and peace, arms control, and other issues that affect international relations. In fact, the driving force behind the creation of the European Union 64 years ago was to give the nations of Western Europe a similar single voice in world affairs. A second reason, which was equally important, was that a strong central government can promote internal commerce as well, with a free flow of labor and capital and marketing under a consistent set of rules and regulations. Both of these reasons were central to the work of the 1787 convention, and if the United States wants to retain or rebuild its role as a major world power, it needs to have a strong central government, like it or not. We can constrain it to the extent possible, and I would support many of the efforts to do so, but we need a strong central government. The proposals offered by the Convention of States would reduce the United States to a fractious, incoherent, and ineffective coalition of 50 states, which is what we started out at, only 13 colonies, 13 states, and that's a huge step backward in a global economy. These proposals would significantly weaken the important economic role of the federal government in regulation, stabilization, and trade policy. And I want to specifically address stabilization because I know that one of the focal points is a balanced budget amendment. I agree that there is a need to constrain federal spending. However, one economist described the federal government as an insurance company with an army. Citizens are often unaware of how much they depend on the federal government as an insurance company to come to the rescue in emergencies, not just earthquakes, wildfires, and hurricanes, but also pandemics and recessions and financial crises. Constrained by balanced budget requirements, states have always turned to the federal government as the insurer of last resort. From the Great Depression to disaster relief, the federal government has been the backup generator when there was a power failure at the state and local level. Among the major pieces of emergency legislation in the last 15 years that would have been very difficult to enact under a balanced budget amendment are the Bush-Obama TARP relief for the 2008 housing collapse, the Trump tax cut, and 3 COVID relief bills, 2 under Trump and 1 under Biden. I think we need to.
Ms. Albrecht, your 3 minutes are up, so if you could wind it up, please.
Yeah, we need to look at other ways to make our shared, if imperfect, national government work more effectively in collaboration with states in economic policy. And I urge you to oppose the resolution to call a constitutional convention. Thank you.
Thank you. Any questions? Okay. Thank you. Next is David Bidoff.
Yes.
Online, I believe.
Yes, thank you very much for letting us present the case for calling an Article 5 convention. And we do so in support of all of these Article 5 applications. And in fact, if I can cut to the chase, I believe that you have all of the elements here to do what our founders intended, which is to have the states with equal authority to propose amendments of errors. That's what Article 5, the intent of Article 5 is. And of course, the states have never, ever done that. But today, as some of you have mentioned, there is an aggregation theory by Rob Nadelson that we are at 33 states, and that's 27 unrescinded balanced budget amendments applications going back to the 70s, and 6 any subject applications going back to the beginning of our country. So how can all of these be put together? Because within the S-133, you have done what other states have done. In fact, 14 states have done this by law, and that is you prescribe for your delegations and for the delegates, you prescribe certain requirements that they must take an oath of office to uphold. And the first and the most important requirement that is in S-133 is that every state gets one vote. The idea that Congress is going to set up the rules and select the delegates was tested back maybe 20 years ago, but basically has been abandoned because there's no history to suggest that a convention of states is not run by the state legislatures. So the states will appoint the delegates and they will go to the convention. They will be given instructions. And generally, the instructions will be one state, one vote. In fact, there has been a convention of states. 19 states attended. They drafted, proposed rules for the Balanced Budget Amendment Convention that was in Arizona in 2017. And my suggestion is that you take what you already have on the table before you, and you put it together in 2 forms. Number 1 is one Article 5 application. And this is, by the way, this has been done, and it's been done in Georgia. Georgia was, back in 2014, I believe, put together a Convention of States application with the 3 subjects, word for word, that you see before you today. But they said these are severable, that each counts for its own convention. And then they did something else. They passed a Delegate Limitation Act. And now Delegate Limitation Acts are very much like what you already have within S-363, I'm sorry, in S-133, and that is one state, one vote is requirement. And in fact, if the convention doesn't come to one state, one vote, you pull your delegation out. You remove their credentials. You basically are walking away from.
Could you wind up your 3 minutes, or if you could wind up, please?
Yeah. The bottom line is, you could pass the 34th Article 5 application. You could trigger a mandamus suit against Congress for never counting Article 5 applications. You could lead the states to calling a safe convention limited to the subjects of a balanced budget amendment, and ratification could be by state convention, which is a vote of the people. And I believe that our country desperately needs fiscal responsibility.
Thank you. Any question? Senator from Orangeburg.
So did I just hear you say you believe that some court somewhere has a right to order Congress to call it?
The mandamus action in the Supreme Court is we've got attorney generals looking at it because they're required under the Constitution to count these applications, and they are not counting them. There is no intent on the part of Congress to ever call a convention of states.
Well, I just asked you a question. Do you believe that some court somewhere has jurisdiction to mandate that Congress act?
Yes, because Article 5 is non-discretionary. Article 5 mandates that they count the applications. They have never counted a single application. They don't know where they're at. They don't know how many there are. They've never had a hearing, and they have no intent of calling a convention of states.
Well, let's say that one group of people says we think there's 33, and somebody says, well, one of those was 200 years ago, so that one doesn't count. Do you think a court can sort that out, or only Congress can sort that out?
That's going to be up to the Supreme Court. The Supreme Court is going to have to decide whether Congress has fulfilled its duty. In the end, I believe that the states can count themselves, and we have been doing that for 16 applications that we've passed in the last 10 years. Each state, in sequence, counts all of the other preceding states that have not rescinded their Article 5 applications. And if you pass this application with the paragraph, you would be self-counting, as the states must do, because Congress is not counting.
Thank you. Any other questions? Okay, thank you. Okay, the only one who's signed up we haven't heard from yet is Paul Armour. Is he here? Okay. Does anyone else wish to address the subcommittee on the Article 5 convention issue? Okay. Does someone wish to?
Hello? Hello?
We can hear you. We can hear you.
This is Joanna Martin. I'm a retired litigation attorney. I would love to speak, please.
Okay.
Thank you.
You have 3 minutes.
Thank you. Thank you. I'm a retired litigation attorney and oppose all applications for an Article 5 convention. This is a complicated issue, and you can't learn what you need to know with a few minutes of people speaking against it for 3 minutes each. This should be set for summer study, where you have the opportunity to become informed by people who prove what they say. You have heard a lot of assurances today of exactly how the convention will work. The proponents assure you that Congress has no power to do anything except set the time and place for a convention, and that state legislatures select the delegates and control what they do. Where does the Constitution say that? It doesn't. The convention lobby made it up. At Article 5 says that Congress calls the convention. Article 1, Section 8, last clause, shows that Congress has the power to make the laws necessary and proper to carry out its power to call, organize, and set up the convention. The only power the states have is to apply to Congress for Congress to call the convention. Article 1, Section 8, last clause, gives Congress the power to make the laws necessary and proper to carry out its power to call the convention, and that includes determining how delegates will be selected. The April 11, 2014 report of the Congressional Research Service, and the link is in the attachments I'm always sending you, shows that Congress recognizes that it has the authority to make the laws which determine the number and selection process for delegates. This Congress may select the delegates, and you sure won't control them with faithful delegate laws. What will you do if, like James Madison in Federalist Number 40, delegates appointed by Congress invoke their right set forth in the Declaration of Independence to throw off the Constitution we have and propose a new one with its own new mode of ratification, such as a national referendum, where those who control the machines determine the outcome. Thank you.
Thank you. Any questions? All right, thank you. Next is Susan Dunn on on Article 5.
Thank you. I'm Susan Dunn, and I also confess to being a lawyer. I'm the legal director for the ACLU of South Carolina. And y'all have listened to a whole lot this afternoon, and I will not belabor my points. I have submitted written testimony, and I have great faith that you will read that testimony. Would like to say just very pointedly that the ACLU does not support the convention calling a convention at this time. We really sense that there's a great deal of energy, but this is not a grassroots movement. This is a well-funded movement by people who have an interest in turning away some of the federal regulations that get in the way of their profit. This is not a country run for profit. It's run for the common good. The restraints that that have been presented to to this body, fiscal restraint and reigning in the local government and the federal government, is even if that restraint were in place, there's a lot of wiggle room in those two labels that could touch almost anything that someone at one of these conventions wanted to raise. And the ACLU agrees with the constitutional scholars, some of whom we disagree with on many other things, but we agree with the constitutional scholars that there's no effective mechanism of limiting the scope, and that once the snowball starts moving downhill, there is no control. As we hear people talking about what they think is going to happen and what the rules are going to be, really the metaphor that we bring to you is Calvin Ball. This is making up the rules as you go along while the game is going on, and there's no way to predict whose theory is going to work here, and this is a dangerous experiment we urge you not to get involved in.
Thank you. Any questions? All right. Thank you, Ms. Dunn. Next is Carla Jones.
Hi, I'm Carla Jones, the Senior Director of Federalism and International Relations at ALEC and our 501c4 affiliate, ALEC Action. I am not an attorney. I'm just here to say that ALEC has long had model policy supporting an Article 5 Amendments Convention of the States for proposing an amendment for a federal balanced budget amendment. We've had that model policy in place since at least the early 1990s, and some records indicate it might even go back to the 1980s. And that was when the national debt was a minute fraction of the 28 trillion it is today. We've published an Article 5 handbook that has been referenced that I'd be happy to share with anybody in the South Carolina legislature and or at this Zoom meeting that dispels a whole lot of the myths surrounding a convention for proposing amendments. And many ALEC members have participated in some of the simulated conventions that have been referenced here, most notably the one referenced by Representative Taylor that took place in Williamsburg. Constitutional scholars from Rob Nadelson, who authored our Article 5 handbook, to Lawrence Lessig, all contend that an amendments convention would not result in the runaway convention that has been conjured up at this meeting. And our constitutional framers included this second segment in Article 5 as a way for the states to introduce constitutional amendments for a time like now, with a sclerotic and dysfunctional Congress that has basically abdicated its governing role. Congress has lost both the ability and the will to govern, and the states need to step in and lead the nation back to fiscal sustainability. Thank you for your attention.
Okay, thank you. Any questions? Okay. Address the subcommittee on the Article 5 issue.
Mr. Chairman.
Senator, I'm going to let the senator from Orangeburg, because you have to go to a hearing.
I would just say this. We've heard this might be the most important thing we ever do, which means it certainly deserves more than an hour and a half subcommittee meeting. And as y'all know from the floor testimony that Senator McLeod could not be here, and she has some input she would like to. I mean, I don't think we're going to get them out today. So I would move to carry them over. If you're not going to carry them over, both of us are voting no. But I can tell you, if we don't work on them before they get to full committee, we got no chance of getting them resolved. So my motion right now is just to carry over those. We've heard the testimony. We should come back in a working session at some point and decide which among the 3 or 4 we're going to pick and what identical does mean. And I think we need some input from staff as to which language mirrors the other languages if it's going to go forward. So I move to carry them over.
Okay. Would you hold that motion? Well, for the senator, I was just kind of
I will, but you got my proxies to vote carry them over because I got a 4:30 meeting.
Okay. All right. Got you. All right, Senator.
Thank you, Mr. Chairman. I will say that I do agree we need to put some more work into this. I think we all agree that it's a very important issue. Staff has a couple of amendments that I've worked on dealing with delegate penalties with the letter to Congress, and we've talked about the restrictions that we could put on it. I think I would like to see us move it out, but I think it's important to get it right before we move it out. And so, I mean, obviously, I don't have a vote on this committee because I'm not on it, but I do, depends on the will of the rest of you, but I do want to see us move forward with this in a short period of time. And I hope we don't carry it over into next year. I would like to see us take action on it sooner than later.
Okay, Senator. Any other comment? Senator from Aiken.
Mr. Chairman, is it my understanding I had stepped out to go to the men's room and we came back in and there was discussion about carrying over. Is it S-133 that they want to carry over?
I think he would want to carry over all of them as far as the senator from Orangeburg is concerned, from according to his.
Every bill on the agenda?
Article 5.
Oh, all the Article 5 bills?
Yeah. Yes. On the Article 5 bills, he would want to carry them all over.
And I heard he said he thought that we needed more work on them.
That is correct. He thought we needed more work on them.
And I heard the senator from Pickens say that he thinks staff has an amendment. Is that to 133 or to something else?
I'd have to see. Let me see how they're drafted.
Mr. Chairman, Senator Rice asked me to draft some amendments, and I had drafted 2 amendments for him. One was to S-133, which is the one which has all the information about delegates, and that would be to put a penalty in if a delegate violated the provisions of the scope of the duty. The other amendment was to S-144, the balanced budget amendment, and that was following language that Senator Rice provided for me, which in essence would use the argument that with all of the states that had in an application of some form or another included a balanced budget in their application for a convention of states, that South Carolina would be the 34th state, and to call upon Congress and in essence to strike S-144 and to say this should be the 34th application, and to ask Congress to call the Convention of States for a balanced budget amendment.
One point of clarification, S-141.
I'm sorry. Yes, sir. Thank you.
And I think, Mr. Chairman, I do believe that staff could work on an amendment between now and, I don't know when we're meeting as full committee. But I think with what we've heard today, we probably could have an amendment ready for a full committee with the information that's available now and plus these amendments. I mean, that's whatever's the will of the committee is.
Okay. Senator from Kershaw, did you want to make some comments?
I appreciate the opportunity to speak since I'm not a member of the subcommittee, but I am one of the sponsors of this bill. I just wanted to say a couple of words in regard, we're allowed to react or speak to some of the comments made, correct?
You're a senator, you can say whatever you want.
I got the mic. Okay. All right. As far, the ACLU leader earlier discussed snowballing and going downhill with this convention of states. And my contention is we're doing that now. I think our nation is snowballing and it is going downhill. And this is a grassroots effort. I know it because that's how I was reached as just a private citizen way far away from politics years ago. And I did not support it at first for that very reason. But I do 100% support it because unlike others who have spoken with passion and sincerity, I don't fear our Constitution. And I think there's a lot of fear about this because it is a big deal. So I don't fear it. I think we need to uphold it and we need to trust it and we need to use it as a tool. Federalism was built into our country. It's one of the things that makes us who we are. And when those lines between the executive and legislative and judicial branches get blurred, we're going to end up having a one government, and it's going to look very different, and the time will have come and gone when we could do something about this. We can do it now. I think this is a nonpartisan issue. Nonpartisan. And I would invite all my colleagues to talk with the sponsors of these bills, to talk with any of us. I've certainly spent a lot of time talking with Mr. Mark Meckler and many, many others that are connected with this. We are the government. They don't own us, and they don't own their positions either. But power is a tricky thing, isn't it? Because when you get it, people don't want to let go of it. And when you get it, your head gets really big and the ego gets big, and then you think you can do anything. And our government cannot do just anything. And we need to call them on it so we can have a proper balance of power. So I support 133, obviously. I appreciate the opportunity to speak with the subcommittee, and I will take note that I can say anything anytime, right?
Not anytime, but when you're recognized, you can.
Thank you for recognizing me, Mr. Chair. I'm concluding my remarks.
Okay, do we have a
Mr. Chairman,
senator from Aiken?
is there I know that Senator from Pickens is here. The Senate Bill 363 is your bill or your resolution that you filed?
That's correct. It's term limits only, though.
Term limits, okay. Did you file one on the balanced budget amendment?
I'm a co-sponsor on that.
Okay, you're not a primary sponsor. The only one that's the BBA primarily is S141.
That's correct.
You're a co-sponsor on that.
But I believe 133 is the only one that's got delegate selection on it. So I think you need to take that up. Now, the question I would have is, do you need to have separate legislation for delegate selection? Well, and I'm not asking the question because I'm not an attorney, but do you need something? Because this is a resolution that is not signed by the governor. Do you need to have something in law that would be in effect after the resolution goes to Washington so that if a delegate steps out of line, you've got action that you can recall that delegate, because there is a line of command in there. But y'all are the attorneys on that.
Mr. Chairman,
Senator from Aiken.
if it's appropriate, I think that since Mr. Meckler's here and he's the founder of the Convention of States Project, and he's been all over the country talking on this and has testified before dozens of committees like this, multiple states, it'd be appropriate to call him back for questions for him.
You'd like to ask Mr. Meckler some questions?
I mean, like the last question that Rice had, I think if
Okay.
it'd be appropriate.
Mr. Meckler, would you come answer some questions?
Mr. Chairman, happy to answer questions. Senator?
You've heard some of the, like the question that Senator Rice had. I mean, can you address that now?
Yeah, I can. The question, as I understand it, is, are delegate limitations enforceable when they're contained in a resolution as opposed to legislation? I would say it's not entirely clear, but it is entirely clear that they are enforceable as legislation. And from my perspective, that's the preference. If you want to impose what I consider to be absolutely binding delegate limitations, then you do it by separate legislation, which requires the governor's signature. I would also clarify, and this is important, that from a matter of law, as a lawyer, and I've been a lawyer since 1988, as a matter of law, your delegates remain, regardless of whether you pass the Delegate Limitation Act or not, under your complete and total control. This is not constitutional law. This is the law of agency, and every business person knows this. If you point an agent to act on your behalf in a legal perspective, for example, to obtain an insurance policy for you, and they go out and they attempt to bind you to a policy that's not within their authority, that action is non-binding. It's literally null and void, ab initio, as Senator Garrett said. In other words, any action taken outside the authority that you give them under this application would be null and void. No vote may be cast that would have any effect if they cast it outside of their authority. So while I understand the impetus, the idea that folks want to impose these delegate limitation acts, and I'm not opposed to them, they are unnecessary for you to have absolute and total control over your delegates at convention.
Senator from Pickens.
The one thing that concerns me is if a delegate needs to be recalled. I think you need to have some clear language in there on how to do that.
So I would say that while I understand that would give you extra comfort, in the same way that you can fire an agent that you employ on your behalf to do any particular given business task for you, you always retain that authority as a matter of common law. This is true, by the way, in the United States. Federally, it's true in every state in the United States. It's true in every Western democracy that I'm aware of. The law of agency is very clear. You can terminate an agent's authority at any time. So recall is a given authority regardless of whether you have it.
I don't disagree with that per se, but I just think if you spell it out, it's very clear.
Yeah, and I would agree with that. In other words, if you wanted to pass a Delegate Limitation Act, I don't think there's any problem with doing so. I just want it to be clear that you already have that inherent authority.
What have other states done? Have they done it by statute or by joint resolution?
The majority of states that have done it, and not all states have done it by statute. And generally speaking, it's done after the resolution is passed, so that you have the resolution on the books, and then the legislature gets together and debates the Delegate Limitation Act itself. I think one of the best I've seen is Indiana, that does, by the way, impose criminal penalties, but all of them, or the vast majority of them, done after the fact, after the resolution is passed.
Have you seen any resolutions with delegate limitation provisions in the resolution?
I have seen states put them in. I don't recall offhand if any of them have passed delegate limitations, and I could look into that and get back to you. I do think it's questionable whether that limitation would be binding or not.
Senator from Greenwood.
Thank you, Mr. Chairman. Mr. Meckler, thank you for being here today. This Article 5, I'm concerned about the ratification, as the chairman was a little earlier. And as I read the Constitution, it says, as part of this Constitution, when ratified by the legislatures of 3/4 of the several states. Now, my assumption is that, it only takes 34, so that's not 3/4 at the convention. And then it says, or by conventions in 3/4 thereof. And so I'm assuming that there would be an opportunity that 3/4 of the conventions, if they were there, and they were all on the same page, could also do the ratification there.
I think that would be an incorrect interpretation. The process and the history are very clear, which is those are two separate actions. In other words, three-quarters of states are required for ratification, whether the amendments are proposed by Congress or the state legislatures. 34 states, 2/3 of states, required to call the convention. And regardless of how many states attend, and I would tell you it will be all 50 states will attend, whether 34 call it or not, whether it's more than 34 actually ultimately pass application, all 50 will attend. And then it goes to states for ratification. And the ratification method is either state legislatures, both houses, just like you're doing when you propose the resolution, or by state ratifying convention. What a state ratifying convention is to me one of the most interesting things in Article 5. It doesn't specify exactly what a state ratifying convention is. The controlling body over a state ratifying convention who determines exactly what a state ratifying convention is actually the state legislature.
And that's my question. It says, as the one or the other mode of ratification may be proposed by the Congress. So it doesn't say shall. Up above, of course, it says the House shall deem it necessary. But you've got to do this.
Correct.
And then it says it may be proposed by the Congress. So the mode of ratification may be proposed by the Congress. That part concerns me. What is your feeling about if all of the language is exactly the same? That may be an impossibility. I understand that. But if all of the language that we were attempting to get the federal government to do, we were all in unison before we went in there, and the language was the same, whether it's a balanced budget amendment or whether it's term limits or whatever we've all agreed on, and we send it in just like that. We set it up, we have the Congress let us have our convention, and then all of our people are bound simply to talk about, go ahead and establish the rules, go ahead and have them immediately vote on the rules. They'll have to, in our document, in our legislation, they have to vote on those rules. They can't change that. Then they go to the first issue, they deal with that. Then the second issue, they deal with that. And then they go home. I mean, do you believe that that is constitutionally allowed? Or is that a method that would restrict them? Or do you think, as we've heard here today, there seems to be a lot, again, this is an interpretation and everybody's got one, okay? So, what's your feeling on that?
I want to make sure I understand your question, so if I might summarize briefly.
Sure.
The question, as I understand it, is could we in advance determine the exact language of the proposed amendments and send our delegations into convention with matching language across at least 34 states?
And then one thing also, that if a delegate moves in any way, I mean, I appreciate your idea about delegates not getting out of control, but I'm like Senator Rice, I want to make sure, trust but verify.
Yes, sir.
If any one of them in any one of the states tries to change that, then that's not the deal. And we all go home, and everything that we've done, every bit of it is void ab initio. The Convention of States no longer exists. I mean, is that too hard to ask for to make happen, to make it practical to be able to be done?
I'd like to answer that question in two layers. First is the constitutionality of it, and I think that's in question.
Okay.
The history of conventions in the United States is one of deliberative bodies, and they were intended to deliberate on a question, not to have a fixed format. And so the courts have ruled on this over 40 times. Our opponents would tell you there's no law, there's no precedent, there's no history. There's an entire treatise that's been written on this by Professor Rob Natelson called The Law of Article 5. I highly recommend it if you're a serious student of this subject. And so we do know the law. And the reality is that over 40 times the courts have ruled on issues surrounding Article 5. And consistently they say it's a matter of history and precedent. And history and precedent would argue for, I wouldn't say this is conclusive, but argue for the idea that these interstate conventions are intended to be deliberative bodies. And we would be depriving them of the right to deliberate over the subject matter of the convention if you put in place the exact same language from every state and limit them to that. I think that is a litigiable issue. I try to avoid those as much as I can. At the second level, I think is the more important question is you're asking about the practicality of this. Before we started this organization 8 years ago, one thing we studied is the over 400 applications, I think it's actually over 500 applications that have been put into the states, by the states, for conventions of states, and asked, why have we never gotten there? In over 240 years of history now, we've never gotten 2/3 of states to aggregate. And the reason it's very difficult to do that. And one of the things that I realized over time is the more specific you are in going in with very specific language, the less likely you are to find allies. And I'll give you a very specific example. If I were to draft, and I'm not qualified to do this, but if I were to draft what I thought was the ideal balanced budget amendment, for example, or the ideal term limits amendment, I would find many people out there who support the idea of term limits and balanced budget who would hate my particular proposition. So coming to the idea of having a convention around these things, it's a very high bar, but it's much easier than coming to exact agreement on the language before you go into convention. And I would actually cite Professor Randy Barnett, I think is the greatest libertarian legal scholar in America. He's at Georgetown. And before I even got involved in this, he wrote a book on the subject and he proposed 10 amendments. And one night we're sitting around talking about why that didn't work. And he said, what I ended up doing was I created essentially people who were opposed to me on every single amendment who were otherwise in favor of the type of amendment I was drafting. So I think from a practical political reality, the bar is so high to get to 34 that it would literally be impossible to do if you were to specify the exact amendments.
And then what about the idea that if 34 states did that, the fact that Congress then would go ahead and act finally because they would rather get their control back as opposed to allowing the states to take over basically that issue, those two issues?
I think history tells us that there is a probability of that. If you look over history, I think the best example is the 17th Amendment, which is not an amendment that I actually like, but multiple times the states tried to press forward with a convention for the 17th Amendment. They got within one or two states, and eventually Congress said, okay, we'll do it. I think that's plausible that that could happen here, probably even likely. I think what we need to be very cautious of as states and state legislatures is that they don't put a fake amendment out there for us. We have an experience with this. The Balanced Budget Amendment got roughly to 32 states back in the 1980s. And then they passed a law in Congress, quote unquote, sort of requiring the balancing of the budget. It was a head fake. And of course, we know historically they never even got close to balancing the budget. So we have to be very careful as states that we are vigilant. And my opinion would be if Congress wants to propose amendments, they ought to do so. We ought to look at them very carefully, and we ought to continue to move forward to a convention.
Do you agree that it would be better for Congress to do this than for us to open this up in a convention of states, if at all possible?
Absolutely not. And the reason I say that is because I spent a lot of time in Washington, D.C., much to my dismay, realizing how deep that swamp is. And I spent a lot of time in state legislatures all around the country over the last 8 years. I have imminently more trust in y'all in the state legislatures around the country and in the people of the states than I do in Congress. The worst things we see happening in the United States of America come out of the United States Congress. They're not coming from the state legislatures. Congress are the worst actors. They have the worst incentives. Their desire, their human nature is to draw power away from the states and centralize it in Washington, D.C., where they exist as political creatures. So I would much rather see this in the states. I have much more trust for the state legislatures and for state delegations.
And just for my folks at home, does your organization take any money from George Soros?
No, we do not.
Thank you very much.
Yeah, I'd like to more thoroughly answer that if I might. I think this is important because you heard allegations we take money from George Soros and the Koch brothers, which, by the way, would be an incredible political feat if it were true. The reality is we have over 100,000 grassroots donors from all across the country. My wife, Patty, is actually the development director for our organization. She works in a high-rise. That's the office over the garage. So that's how our organization is funded. And these allegations that we're somehow some big dark money organization, I don't know what that means unless you consider the roughly 100 people here in support of the organization to be dark money grassroots activists.
Do you have more questions? I'd like to ask you a couple questions.
Yes, Mr. Chairman.
What's your view of the aggregation theory with regards to the balanced budget amendment?
I disagree with the idea that if South Carolina were to pass the balanced budget amendment, that it would be the 34th state. I can say unequivocally, absolutely factually, it would result in contentious, difficult, messy federal litigation. I try to avoid that kind of litigation. This is the reason that we use the same language in all states, because going into federal litigation is always a mess. It's a long-term mess. It costs millions of dollars, and you never know what the outcome is going to be. It's my opinion, if a state claims to be the 34th state and files that litigation, it will stop the Article 5 movement dead in its tracks. I think it's a terrible idea. I don't believe it's legally correct. And at the very least, it would start a litigation firestorm.
Do you think that the resolutions that contain fiscal restraint, along with term limits and limitations on federal power, does the category fiscal restraint is amendments under that category, included in that category?
Yes, Mr. Chairman, I do believe a balanced budget amendment would fit under the category of fiscal restraints. However, the question on aggregation and the question that courts look at or scholars look at is what was a state's intent when they passed a particular application? And in the case of a standalone balanced budget amendment, I think it's very clear that the state was not intending, it was never discussed nor debated nor drafted, that a state would attend a convention that was intended to address other categories of things like beyond fiscal restraints, like scope, power, and jurisdiction of the federal government, like term limits. When a state passes a balanced budget amendment application, they intend to go to a convention and to be limited to a discussion of a balanced budget amendment. So I don't believe it's appropriate to aggregate something like that based on the theory of state intent.
Would it create a problem if a state passed a balanced budget resolution and a resolution that provided for fiscal restraint, term limits, and restraint of federal power?
Mr. Chairman, I don't believe there's any conflict in those things, and having multiple applications on file with Congress should not create any conflict or any problem for a state or in measures of aggregation.
What is your view on the language in Article 5 that says the proposed amendments will be ratified by the legislatures of 3/4 of the states by convention or by the legislature as may be proposed by Congress? So does that give Congress, in your view, does it give Congress the absolute authority to dictate that these amendments would be ratified either by the General Assembly or by a state convention? Do you think that gives them the absolute authority to make that call?
I do think they have the absolute authority to make that call. As pointed out by Senator Garrett, it's not mandatory that they make that call, but they do have the authority to make that call. In all instances but one, Congress has chosen the ratification method of the state legislatures. I believe they would be likely to do the same thing, but I don't worry about the idea of state ratifying conventions, mainly because the body in charge of state ratifying conventions are state legislatures. Right. So it's essentially one and the same. The states decide how they're ratifying convention.
Have you ever read Pauline Meyer's book, Ratification?
You are speaking to my sweet spot, Senator. I actually had a chance to meet with Professor Meyer about 2 years before she died. Went out and sat with her at MIT. She is, in my opinion, the greatest modern historian of the Revolutionary era. And the book Ratification, if you want to understand the process, what really went on, what really happened in the States, Professor Meyer was the authority. So you're speaking right to my heart when you bring up Professor Meyer.
Well, that was very insightful, that book, and
incredible.
You realize that state conventions conventions were a very normal and frequent process in the founding era. And they did kind of stick to what they were supposed to stick to. And I think a jurist, of course, we have a lot of jurists who don't look back at history and what the terms meant at the time they were passed. We have too many activist judges, but I think a judge who really seeks to apply what the meaning of these terms at the time that they were actually adopted, and anyone who is a textualist or originalist would really put some parameters around a runaway convention. Personally, I've kind of studied myself to that position. I didn't always hold that position. Do you agree with that position?
I absolutely agree with that position. And I have to say, Mr. Chairman, I haven't met anybody sitting on a committee that has read ratification by Pauline Meyer. So I know you know your history. That is the real, true history of the ratification of the Constitution.
And what do you how much of a protection is the 3/4 ratification either by convention or state legislature? How much of a protection or is that for the states from the product of a runaway convention?
Yeah, I would go so far as to say, in my opinion, it's an absolute firewall. And it's a matter of math. You'll have to forgive me, I'm an attorney, so I'm not necessarily that great at math, but simple math I can do. If it takes 38 states to ratify anything that comes out of convention, that means only 13 states to stop anything that comes out of convention. This is a nonpartisan math problem. For anything that either side would consider radical, it can be stopped by 13 states. And I'll do the simplest one that I hear all the time, which is I have people tell me, Mark, you're going to damage the Second Amendment. They're going to do away with it. They're going to limit it. As I understand it, there are currently 24 states where you can carry your handgun inside the state capitol, 15 states where you can actually carry an open long gun inside the state capitol. I would challenge anybody to show me the 38 states that would ratify the idea of repealing or limiting the Second Amendment. And Mr. Chairman, just to drive home that point, because of what I do for a living, I've had an opportunity to make this offer to millions of people. I've asked people, well, if you're afraid of a particular amendment, then send me the amendment in rough language and the 38 states that will ratify it. And I say this as a conservative in particular. I've made that offer to millions of people on all kinds of television and radio shows. I've never received a single email because I believe, Mr. Chairman, that it is actually an impossible task.
Well, I began my engagement of this issue being opposed to it and studied myself to where I supported it. And really, I did it because I do believe, I think the greatest quote of all in the Federalist Papers is Madison in 51, where he says that what is government but the greatest of all reflections upon human nature? If all men were angels, no government would be necessary. If angels were to govern men, no restraint on government would be necessary. But in creating a government of men over men, the great difficulty lies in this. First, you must empower the government to restrain the governed, and secondly, you must compel it to restrain itself. And it's a brilliant statement about the framers' accurate view of human nature. And I do believe that the fundamental difference among political philosophies really lie in differing views of human nature. Thomas Sowell wrote a great book upon that called A Conflict of Visions. Yuval Levin, great book just recently on the Great Debate, comparing Edmund Burke and Thomas Paine and their contesting each other about the reality of the French Revolution and what was going on. I think, of course, Burke was right. So what the framers designed was the number one principle I tell people in the Constitution is, if you really understand it and read it, is this: we don't trust human beings with concentrated political power. You can sum it up that way. That's the basis of the separation of powers, of federalism, of bicameral legislature, of the Bill of Rights. And they did that because they had an accurate view of human nature and built a government premised upon that accurate view. The French Revolution took an exact opposite view, and it ended in disaster. And so the same people who said that created this. And in fact, Madison in 43 said it's useful for alterations to be suggested because of experience. We couldn't foresee everything that would transpire. And he also said it's neither wholly national nor wholly federal. I mean, and that's where I see really the separation of powers concept even at play here. As far as the way you amend the Constitution, you can do it nationally, you can do it federally, which they meant by the state, right? And they put it in there. So I guess what I really came around to this conclusion that they put it there for the states to have an arrow in their quiver I don't want to unilaterally disarm because we don't have enough armament as it is. And so I don't want to unilaterally disarm. And I do have a great concern. I had great concern about a runaway convention, because I do believe that the framers had human nature right. And I believe that this culture today has human nature completely wrong as far as popular culture. And if we were to just de novo come up with a constitution, and I also think that politics is downstream of culture, culture's downstream of your worldview. It's your worldview and culture that really determine your politics and your political positions. And our culture is so debased and so far away from the culture that the framers and what the cultural distinctives and what they believe as far as with regards to human nature primarily is so far away from reality. We would come up with, if we just by a majority vote adopted a constitution, it'd be disaster. But the three quarters of the states ratification process is the safeguard that brought me studying and understanding how conventions worked in the past, and any good judge who exercised judicial restraint would cut off any kind of runaway convention, number one, because there weren't runaway conventions back in the day. And number two, if we just had a de novo, we're going to we're going to come up with a constitution on our own, it'd be disastrous because of what it's rejected when it comes to human nature and the structure of government. But that's not the way the framers envisioned it. And again, we see once again, they didn't trust human beings with concentrated power. That's why they put a 3/4 ratification provision in there. And I also think it's a desperation move. I think the framers understood it would be a desperation move pretty much, but I think we're probably in desperation move territory with regards to what's happening in this nation. So that I've had a journey. I'm just reflecting how I've had a journey where I've actually studied myself to where I do support this. Now, I do think that I think 133 is probably what I would prefer to pass. I don't know if we do the balanced budget amendment too at the same time, but balanced budget amendment is subsumed under the concept of fiscal restraint.
Mr. Chairman, can I ask one more question?
Sure. Yes, Senator.
Before we go to that?
Yes.
Do you know of anything to give us comfort? The runaway convention has always dogged me. And then it goes back and says the Congress can help us or decide how we ratify. That worries me. It's always worried me. Is there anything else you think that we could do to help Senator Rice and myself feel like there's some method constitutionally to be able to slate a convention that is almost iron-proof, that'll only talk about these two issues and nothing else? Is there anything else we need to know as legislators, based upon the law and the common law and the doctrine of the law, that we need to know that might help us?
Well, I'd start by telling you that I think we've already done it. When you have 34 states, and remember, we've got to get to that threshold, which is not easy. If 34 states have all agreed in advance what the subject matter is, so that means they're going to commission their delegates, as you will, to only have authority to deal with those three subjects. So I think you've got that. Along the way, requires 26 states to get anything out of convention. So you have to get a majority of states to agree to something. And that obviously is going to wipe out some of the crazier ideas anyway. Most of the commissioners are going to be there. They would like to get something done. This is human nature. We talk about knowing human nature. They're not going there to waste their time. They're unlikely to propose things that they don't believe that can be ratified. And then ultimately you have the 3/4 bar in the event that I'm wrong and it can run away. I think one of the most important things that we can do is be guided by history. Patrick Henry, in his famous "Give Me Liberty or Give Me Death" speech, we all know the line "Give me liberty or give me death." But one of the things he said in that speech, it's probably my favorite speech in American history. He said, "I have no other light which my feet can be guided than by the lamplight of history." I see you know that quote, Senator Garrett, and I like that because I'm going to look back in American history in regard to convention, and what I'm going to see, what you would see, 11 conventions before 1787. Contrary to the slanderous allegations made about the founders in 1787, that convention was not a runaway. If you read the commissions of the delegates, all but 2 states gave the authority to their commissioners to take any and all actions necessary to render the federal constitution adequate for the exigencies of the Union. So that is a slander on the founders. And think about the founders at a time when honor was held in such high regard that they just ignored their instructions. It's simply not true. Since 1787, roughly another 30 conventions. Here's the most amazing thing, human nature being what it is. In all those years, in centuries, we have no evidence of a runaway convention in American history.
Well, I sat down and studied Madison last night, 40, and he pretty well lays out, he talks about the authority of the convention. So he goes in and he goes to great detail, talking about, it appears that they were there to work on the Articles of Federation, and then decided not to. In other words, then they decided, but they had general authority, okay, and that was general authority to make the Constitution. And he's arguing here that they had embodied in their ideas beyond just fixing the Articles of Confederation. I just want to make sure that we don't open the door to do what our founders did. You know, we got to make sure that whatever we do, we don't give any general language that gives our convention any authority whatsoever to do away with this great document. And if we do, then we have failed. And I don't want to be on the side of history that failed our union, because this document is by far the most beautiful thing man ever created with the help of God.
I agree with you. And I would say, and I believe it's Federalist 41 where Madison says, if you want to know the authority of the states, look to their commissions.
Sure.
Right. And so if you do look at those commissions, and by the way, very few people have read those commissions. I have read those commissions. Until Professor Rob Natelson read those commissions, literally until he went to the National Archives and pulled those, nobody had looked at them since 1787. And so there was a fallacy that was created that this was a runaway convention. That fallacy was created because after 7 states had actually commissioned their delegations and given them this broad authority, Congress weighed in, as Congress tends to do, finger in the air, and said, well, it looks like the states are getting together. We better say something. And they actually put in what they called a recommendation. They had no authority under the Articles to call a convention or to propose amendments. They said, we recommend the states gather in convention to propose amendments to the Articles of Confederation. So that's where this idea comes from. And then I want to add one more layer. I think this is very important. We should know where the ideas that we profess come from. And if you want to know where the idea of a runaway convention comes from, it comes from Chief Justice Warren Burger. Burger, you might recall, was the liberal activist Chief Justice who was the deciding vote on Roe versus Wade, signed Roe versus Wade. In the years after Roe versus Wade, there was a movement in the states to call an Article 5 convention to overturn Roe. The right move by the states had they wanted to do so. At the time, the country was much more conservative back then. And ultimately, what happens out of that is somebody asks Chief Justice Warren Burger what he thinks about the idea of this convention to overturn the seminal vote of his career. And he, of course, says that's a crazy idea, and we ought not to do it because we might lose our beloved Constitution in a runaway convention. He then employed somebody aptly named, I think, by the name of Charles Swindler. Swindler worked for him on many committees in the Supreme Court, many organizing committees in and around the Supreme Court. They went out and they got law professors at Harvard and Yale to write articles about the idea of a runaway convention. And this is where we get this idea in the American lexicon. So it comes from the radical left attempting to prevent conservatives from using the tool that the founders gave us because they understood that power would be centralized. And the radical left has pushed this idea. And unfortunately, some on the right have been co-opted, have bought into this idea. And I'll conclude with this to know how broadly that has happened and where the sides line up. Every single nationally known conservative figure in the United States of America that's spoken on this topic is in favor of it. Every single one. There are no exceptions, literally. Every single radical left-wing group in the United States of America weighed in on a press release. I'm not just saying this, on a press release 4 years ago on Good Friday, saying that this is the most dangerous idea in American history. It was led by Common Cause, Center on Budget and Policy Priorities, signed by Planned Parenthood, La Raza, Code Pink, MoveOn.org, Daily Cause, and the list goes on and on. It's breathtaking, the expanse of this list. So lined up on either side of this idea is the radical left saying absolutely not, and every nationally known conservative scholar, thinker, talker, and Mr. Chairman, a lot of these thinkers have gone through the same process you did. And when I listen to the way you went through the process, it reminds me of great thinkers I admire. Rob Natelson, who went into this opposed to the idea of convention of states. Mark Levin, who went into his research opposed to the idea of convention. The time when the Attorney General meets, originally opposed to the idea of a convention of states. These are people who went through the same process you did, read the history, understood the language, and they do not fear the idea of a runaway convention.
Senator from Pickens.
Yeah, one quick question. Is there any question that one state, one vote, regardless of the number of delegates to any given state?
There is no question about one state, one vote. It's called a convention of states. A state is a single sovereign entity. It's not called a convention of delegates or a convention of voters. All throughout American history, I described roughly 41 conventions that have taken place, all one state, one vote. There was actually an attempt in the Washington Peace Conference prior to the Civil War, where they were trying to prevent the Civil War. The larger states thought they should have more votes. And so they took a vote on it to see if they could give themselves more weight. And they took that vote, one state, one vote. And of course, giving the larger states more votes was defeated. So we have zero history in the entire history of the United States of America. The courts have repeatedly ruled that these conventions are ruled by history and precedent. There is no precedent for that. And I would add one more thing, which is the small states would all withdraw if the large states tried to do that.
And when it comes to, if we wanted to enact a statutory provision with regards to delegates and controlling delegates and runaway delegates, we have, other states have done that. And you cited Indiana as a state that is, you consider a model statute, is that correct?
Personally, that is my favorite statute in regard to delegate limitations. They took the lead. I think they drafted something very thorough. We also have model legislation we could provide to you.
Of course, that's not necessary to do now. That you have plenty of time to do that. But absolutely, it's something that we could do. But we don't have to wait on that to pass this resolution.
No, and in fact, I think one of the things I've seen in the past is opponents of the Convention of States attempt to muddy the waters, getting into the details of what the Delegate Limitation Act should exactly be. It's much simpler to pass the resolution and later on to add on a Delegate Limitation Act.
Okay. Thank you. Any other questions? Thank you.
Thank you, Mr. Chairman.
Just Mr. Chairman.
Wait, do you have a question?
The current S-133 does have language in it that limits the application is limited. It's on page 3 of paragraph 5, lines 6 through 13.
The question was, this is a joint resolution. I was questioning should we? I think I'm convinced we should, if we pass this.
Put it in statutory law.
Put it in statute. And that's really the point I was getting at. This language is in a joint resolution, not in a statute. And other states have done statute.
Well, and I also think it's important for people that are watching this online that they know that there's language in this joint resolution that limits it, which is far more than some of these other states that have already passed it. I think there's 15 states in the world.
15 states. You guys would be the 16th
already done it. And I've looked at some of these other states, and some of them don't have. They have very little language, if any, in there that limits it, and some of them. So. I just know that several of the speakers today were concerned about that, and I just think it's very important that we point out this joint resolution does have language in it that limits it. And it's very specific that it's on 3 topics, and it's also very specific that it requires under Article 5 that the proposed amendments that come out of any convention would have to be ratified by either the state legislatures or by special state ratification conventions. and that we recommend that Congress select ratification by the legislatures of the several states. At the appropriate time, I think we should move S-133 and S-141 forward to the full committee.
S-141, which is
the Convention of States on a
balanced budget.
Yeah.
Okay. We have that motion. We have a second. Do we have any discussion?
And do we need to take any action on Senator Hutto's motion that he made before he left?
No, well, he wants to, he wanted to move to carry it over. So
did he actually make the motion?
He did, but then I asked him to withhold it.
Okay.
But we probably ought to act on it. And so he's given me instructions that that's what he wanted to do. So on behalf of Senator Hutto, I'll introduce a motion to carry over all of these Article 5 bills. And he had the Senator from Columbia's proxy. That would be a second. So we need to take a vote. Would we to carry over these Article 5 bills?
I'm opposed.
Okay, all in favor indicate by saying aye. All opposed indicate by saying no.
No.
No. Okay, so the noes have it 3-2.
So I make a motion at this point in time that we move S-133 and S-141 forward as favorable to the.
Okay, we have a second.
With the understanding that there may be amendments offered at the full committee.
Okay. Any discussion? Being no discussion, we'll move immediately to a vote. All in favor indicate by saying aye.
Aye.
And aye. And pursuant to Senator Hutto's instructions, both Senator Hutto and Senators McLeod vote no on that. So that's a 3-2 vote. They pass. Okay. Thank you. All right. If y'all would, thank you.
Thank you.
If you would bear with us, we have another bill on the agenda, and it is 174, S-174, dealing with independent expenditure committees. And I know we have some people who want to testify to that. And who is Heather? Ms. Anderson is.
So you were just watching the South Carolina subcommittee hearing with testimony for our Convention of States resolution. Representative Bill Taylor, he introduced the resolution. He is a champion of the Convention of States resolution. He's been with us from the very beginning. And of course, you heard Mark Meckler, who had a very passionate testimony. He said at one point that it's time for the states to stand up and make the federal government uphold their end of bargain. I thought that was an amazing moment from Mark Meckler. Of course, we heard the South Carolina State Director. He testified as well, and there was, of course, the Grassroots volunteers. They filled not one, not two, but 3 overflow rooms. Over 70 COS South Carolina volunteers and supporters showed up today, even though it was only 1 day notice. We still had 70 supporters show up, 70 volunteers show up. It was absolutely amazing to hear the overwhelming support that we got from our Grassroots. We heard many passionate testimony today, one that was from a 13-year-old Natalie Shriver. She said she wants to stand with the United States, with America, and uphold the Constitution by calling the very first Article 5 Convention of States. What amazing, a young patriot, 13 years old, still in high school, standing with the Constitution, standing with Article 5, standing with the Convention of States. Of course, Mark Meckler came back after we heard some other testimony, some negative testimony. He came back and he clarified exactly what Convention of States has the authority to do and what an Article 5 could do, and dispelled any of the myths that were spewed earlier from some of the testimony from JBS and other people who are against Article 5. I'm here with Rita, and Rita, I want to ask you about the aggregation one. That was something that kept getting brought up over and over and over again in this testimony. Can you tell for the viewers exactly what aggregation means and just the myth that was spread today throughout the testimony?
Absolutely. Well, we know, according to the text of Article 5, that it takes 2/3 of the state legislatures applying for a convention to propose amendments in order to trigger the Convention of States under Article 5. So aggregation refers to which applications by the state legislatures count to be part of that 2/3 or 34 state applications, which is the required number. And in order to be counted toward that 2/3 threshold, that magic 34 number, applications for an Article 5 have to describe the same agenda for the convention. They have to describe the same subject matter for the amendment proposals. In fact, we know that's why there has not yet been an Article 5 convention to propose amendments, because although there have been over 400 state applications in American history, there have never been 34 on the same subject matter. So right now, Convention of States, our effort is at 15 applications, and all 15 apply for a convention to propose amendments that do three things: impose fiscal restraints, limit federal power and jurisdiction, and set term limits for federal officials. So that's what the whole aggregation conversation was about. You did hear a lot about that. Of course, Mark Meckler expertly fielded all of those questions. You would never know, Andrew, that Mark has actually been up since 3 o'clock this morning. As you mentioned earlier, this committee hearing was a last-minute change. It was actually supposed to be happening tomorrow, and then just yesterday afternoon, they changed it to today. So Mark had to get up at 3 o'clock this morning and head to the airport to get to South Carolina, but he was at the top of his game, and you would never have known it. He was great. I wanted to talk for a minute, if I could, just about some of the opponents. Like, they gave us so much material for fact checking that I don't think we can get through it all, but I just have to highlight a couple of them. Evan Mulch has a bad habit of showing up at these hearings and just flat out making stuff up. He claimed that Convention of States had listed Antonin Scalia, the late Justice Scalia, as an endorser of the Convention of States project, and that's just a lie. We never claimed that. However, we have pointed out many times that Scalia did speak in favor of an Article 5 convention to rein in federal power, including restraints on Congress and the judiciary. But here's a big one. Mulch also said that Justice Scalia died before Convention of States ever started. Well, folks, that is just objectively false. COS started in 2014 and Justice Scalia died in 2016. So I'm going to suggest that we just can't treat much of his testimony, Evan Mulch's testimony, as credible. Another opponent said the Constitution isn't broken, so we just need to elect the right people. How's that working for us, Andrew?
It's not working very well at all. I mean, look what happened after the Tea Party. It sounded so great, just get the right people in office, and it didn't work. So, and that's really fresh within the minds of Americans. This isn't something that happened in like the 60s or something like that, the Tea Party movement. This happened recently, and getting the right people in office just doesn't work, especially when you have a media that is just so absolutely corrupt. They will not tell the truth on any side. So you can't control, or you can't believe that getting the right people in office will work. And many of the senators today, they talked about that. They brought up the Founding Fathers, the Federalist Papers. I believe he talked about 51, one of the senators, about human behavior, that if men were angels, there'd be no need for government. And the founders just absolutely knew that human behavior was corruptible. So just trusting to get the right people in Congress is just the wrong solution. The solution is to call a convention where the power would be dispersed among the states to propose amendments to change the Constitution or to amend the Constitution. So the right people in office is just it's a trope, and it just kind of, after you hear it so many times, like, why are we still hung up on this?
Absolutely. And what's frustrating about hearing this same argument over and over again is that that's exactly why the framers gave us the Article 5 convention to propose amendments, because they knew that the states would need a recourse when the federal government assumed more power than it was legitimately supposed to have. Another opponent was an attorney, Bill Olson from Virginia. He claimed that because Article 5 gives Congress the power to call the convention, that means Congress controls the whole thing and even can choose the delegates. Well, that's not true. The word call historically in this context is a term of art, and it simply gives Congress the time to name the power to name the initial meeting time and location. That's it. It doesn't give Congress control over the delegates or the rules or anything else. He also claimed that state legislators lose control once the convention actually starts to meet. And that is just absolutely false too, because the delegates act as the agents of their state legislatures and are accountable to them throughout the process. And if you got to hear this, you heard Mark Meckler talk about the basic common law principles of agency, which do apply in this setting. And that means that the commissioners who go to the convention act as the legal agents of the state legislatures who send them there, instruct them, and can recall them at any time. So lots of fact checking to do. Okay, my favorite, Andrew, this is my favorite falsehood that was made. It was so funny because it was actually the same opponent. This woman claimed that Convention of States is funded by the Koch Foundation, and then about a minute and a half later said that George Soros was also funding us. So wouldn't that be just amazing? That would be a major achievement by any organization to get funding from George Soros and the Koch Foundation. And by the way, both claims completely false. No truth to that.
Yeah, I find that so funny. Like, just get your narrative straight. Either we're funded by the Koch or we're funded by the Soros. I don't understand how we can be funded by both. That just doesn't logically make really much sense. And I think it's funny too, going back to the talking about Congress having control of the delegates. It just doesn't really make sense to me that the founders who thought of just about everything, that they would put a redundancy in Article 5. They would have the first clause be for Congress, and the second one would also be controlled by Congress. That just doesn't make sense logically. And if you really think about it, the founders debated everything. Why would they make this type of mistake, incorporating a redundancy? Just when you think about it logically, a lot of these myths just don't hold. They don't stand up when you under closer inspection. And so same with where we get our funding from. That's just not true. We actually get our funding from, a majority of it comes from the grassroots, and Mark talked about that at length today in the testimony. So these myths, they're humorous, but at the same time, it's like, wow, these myths need to go away because they're just abject lies, what they are.
That's right. Totally inconsistent, just as you said. And like you said, the founders were competent statesmen, to say the least. They would have been completely incompetent if what these opponents were saying were true, because the founders' whole goal with the Article 5 convention was to give the states a way to bypass Congress in order to achieve needed constitutional amendments. So if it were true that Congress actually controls the whole convention, then basically what you're saying is the founding fathers were idiots. Well, I just don't believe that, and history does not bear that out. I know we were hoping to have Mark Meckler with us, so let's give just a couple minutes. He may be busy with the grassroots. He loves spending time with our grassroots supporters when he's on the ground in a state capitol. And I know there were so many of them there today. The estimate that I heard was 70 people, 2 overflow rooms they had to open.
3 overflow rooms, I think.
3 overflow rooms. And what's so impressive about that, it would be impressive under any circumstances. But remember, this committee hearing today was just announced yesterday. because we thought it was going to be Thursday. Everybody was planning to be there on Thursday. So with 1 day's notice, our South Carolina Grassroots got 70 volunteers to the Capitol. And, you know, one lady, I can't remember, was it Joanna Martin, who calls herself Publius Hulda sometimes,
Yes.
said, Convention of States is not a grassroots movement. Well, she ended up telling that to the 3 overflow rooms of volunteers who took time off work and spent their entire day to be there for this committee hearing. Convention of States is a grassroots movement, and it's when the grassroots, people like you and me, show up and stand up and speak up at these committee hearings that we will empower our state legislators to do what they need to do and take their power back and rein in Washington, D.C. I don't know if we've heard any word from Mark yet.
You know, while we're waiting for Mark, though, I want to bring up one point that you just talked about the grassroots. One of the persons who offered testimony who was an opponent was Judy. I'm failing to remember her last name right now, but she shows up for every single one of these hearings, and she says she's from California. I don't really fully understand why she's showing up at these hearings. She's not a constituent, and you know, if there was a hearing in California, by all means show up in California, but this was for South Carolina. So it just shows you that the people that are showing up for these hearings, they're not genuinely involved in the grassroots there. So, and their opponents that are speaking up from their home state in California. So, but all of the people who were proponents, they were the grassroots in South Carolina. They lived there. They are going on behalf, or they're going and asking their state representative, their senator, to support our resolution because they believe it with their whole heart that this is the solution as big as the problem that is going to rein in the federal government's power.
Yeah, and you're right on with that, Andrew. Not only, I think it's Judy Kaler that you're talking about. She does show up in all these different states. And not only is she not a constituent, but she's also not an expert. She doesn't have any particular expertise or credentials. And, you know, while we're on that subject, I'll just mention that my article, which is out today on the Stream website, so just Google the Stream and my name, there it is, producer G has it up, is all about this whole issue of knowing who the experts are, because you have all these people who come to these committee hearings, which is wonderful. We want citizens to do that. We want constituents to do that. But all these people show up at committee hearings, and some of them, like Joanna Martin, like Judy Kaler, claim that they are constitutional experts or some kind of experts, and they have no credentials. They have no experience. So it's important when you are going to rely on someone's testimony to first decide, you know, if they're claiming to be an expert, do they have the chops to back that up? Are they really an expert? And, you know, citizens don't need to be experts because they're the constituents. It's their job to tell their legislature what kind of measures they want to pass or to fail. But if you're going to come and claim to be an expert, you better have the credentials of a Mark Meckler or a Rob Nadelson or a, you know, Senator Coburn. You better have something to back that up. It's really important.
There was one grassroots volunteer who showed up. He even said he didn't have the credentials. It was Ken Clark. He had a really great testimony, and he knew his stuff on Article 5. He was very eloquent, but when asked a question that he was unsure about, he said, "I'm not an attorney, and I don't feel comfortable answering that question. I think you should defer to Mark Meckler." So it shows our grassroots, they are very knowledgeable, but they know when to defer to someone of authority like Mark Meckler. I just wanted to point that out. I thought it was absolutely amazing when Ken Clark said that.
Yeah, and that, you know, that gives him a credibility because he knows his limitations. He knows what he's qualified to testify on and what he's not. So that is really important. In case you're just joining it or in case you missed the vote, we did just stream live a subcommittee hearing of the South Carolina Senate Judiciary Committee. So this was a subcommittee. They did vote at the conclusion by a vote of 3-2 to recommend passage of the Convention of States resolution to the full Judiciary Committee. So the next stop in the South Carolina Senate will be the full Senate Judiciary Committee. We don't know yet when that will be, but stay tuned and we will certainly keep you posted on when that's going to happen. And just to give you a little bit of the background there in South Carolina, a few weeks ago, the South Carolina team packed overflow rooms to watch a subcommittee of the South Carolina House Judiciary Committee. So the companion bill on the House side was already heard. That's a picture of that. Look at that committee overflow room. It's amazing. Subcommittee overflow room. This isn't even the full committee. And that House subcommittee also voted 3-2 to advance our resolution. So today the Senate subcommittee has done its job. Now we are waiting for full committee votes on both the House and the Senate side. If we pass those full committees there, then we go to the floor. And South Carolina, I know, would like to be in this race to be state number 16 to pass the Convention of States resolution. We had hoped to have Mark Meckler join us, but he just can't pull himself away from the Grassroots team there. So, Andrew, I think it's probably time for us to say goodbye to our viewers.
I think so too. Thank you for staying tuned this entire time. It was an excellent hearing. We passed 3-2 in this subcommittee, so that's a victory for Convention of States and for the Grassroots and for the entire South Carolina team, which is absolutely amazing. If you are tuning in and you have not yet signed the Convention of States petition, please go to www.conventionofstates.com, sign the petition. Get involved also by going to the Take Action page, where you can join your local community, become a district captain, become a leader in this fight for liberty. And we will see you again at the next hearing when it comes up, or we will see you on Tuesday for another edition of CUS Live. Thank you so much, Rita Peters, for being here with us.